I want to thank our speakers and panelists for joining us today and express our profound gratitude to Senior Judge Laura Livingston. Laura, where are you? And Betty Valley Torres, the Executive Director of Texas Access to Justice Foundation. They have just been invaluable here in bringing this event together, and we're privileged today to hear remarks from Texas Congresswomen Sheila Jackson Lee and Lizzie Fletcher, the Chief Justice of Texas, Nathan Hecht, Supreme Court Justice Brett Busby, the CEO of Genesis Women's Shelter and Support, Jan Edgar Langbein, and of course, Harriet Myers, not only a partner at Lock Lord, but chair of the Texas Access to Justice Commission. And she's been a founding co-chair of our LSC's Leaders Council, principal architect of today's wonderful forum, and she's had to put up with me for almost a decade. Today's program also features two panels. The first, moderated by Texas State Bar President Cindy Tisdale, focuses on domestic violence. Panelists from leading organizations supporting Texas survivors will discuss the importance of a coordinated response to domestic violence. LSC's remarkable president, Ronald Flagg, moderates a second panel, which features members of the Texas Access to Justice Commission, who will discuss the role of regulatory reform in expanding access to legal help for low-income and rural Americans. Well, we are gathered today at LSC's very first forum in its 50th anniversary year, because on July 25th, 1974, Richard Nixon signed the LSC Act, not as a charity initiative, but as a way to preserve a basic right and help low-income Americans help themselves. And I quote, "We have learned that legal assistance for the poor, when properly provided, is one of the most constructive ways to help them help themselves. We propose simply to protect and preserve a basic right for all Americans." Well, protecting this basic right has been central to the mission of LSC since its founding. As another United States President, George H.W. Bush, observed 10 years ago during LSC's 40th anniversary, and I quote it, "LSC plays a vital role in our civil justice system and our country, funding programs in every state that make a crucial difference to millions of low-income Americans. Without the assistance offered by LSC-funded programs, many low-income Americans would simply be excluded from access to civil justice system. For 4 decades, LSC has championed this core American value, equal justice, equal access to justice," unquote. Well, this quintessential American promise of equal access to justice is the inspiration for our 50th anniversary commemoration and outreach campaign, which we are calling Protecting the Promise. The many projects, events, and initiatives we have planned across the country for our Protecting the Promise campaign will shed new light on a wide variety of issues related to ensuring equal access to justice and our persistent, I believe, disgraceful failure to make this foundational value a reality for so many Americans. LSC's 2022 Justice Gap Report quantifies this failure sums up the situation in one head-turning statistic. Low-income Americans do not receive any or enough legal help for 92% of their substantial civil legal problems. Chronic underfunding of LSC and its grantees is helping to fuel this crisis. LSC's network of 131 grantees with more than 900 offices across our country, employing over 10,000 lawyers and paraprofessionals, they're working so hard to stretch their limited resources to cover as many individuals and families as they possibly can. Yet our studies have confirmed that as hard as they're working, they have to turn away so many because of a lack of resources. And here in Texas, while LSC's 3 grantees closed an impressive 68,788 cases, to be precise, in 2022, the highest among all states. Only a fraction of those eligible for LSC-funded services actually received them. Estimates suggest that no more than half. Some accounts, unfortunately, in places in our country, less than 10% of those qualified receive the assistance they need. So as grateful as we are that Congress increased LSC's funding to $560 million last year, clearly much, much more is needed to close the justice gap after years of wholly inadequate resourcing. For fiscal year 1994, 30 years ago, Congress appropriated $400 million for LSC. Well, our current appropriation has increased only modestly, if you want to call that an increase, since then. Not remotely enough to keep up with inflation, much less the increased demand, need for services resulting from recessions, population growth, the pandemic that have occurred over the last 3 decades. And I'm sure that those visionaries who advocated so effectively for the founding of LSC would, as we are, be so very proud of the wonderful work of our grantees. But at the same time, I think they would be absolutely appalled at the lack of appropriate funding. To remedy this, last March, LSC requested from Congress $1.5 billion for its 2024 fiscal year budget. This request not only responded to the chronic underfunding of LSC, but also recognizes the vital role that equal access to justice plays in maintaining one of the pillars of our democracy, the rule of law. As Ivan Fong, Executive Vice President, General Counsel of Medtronic, powerfully observed a few months ago at LSC's Access to Justice Forum in Washington, and I quote him, "When people don't have access to justice, or even perceive that they can get a fair shake in our court system, that erodes our commitment to equal justice under law and to the rule of law. The consequence of this failure is that it risks causing people to lose faith in our democratic system and our system of justice." As we launch the Protect Our Promise, the Promise campaign, LSC will seek to raise even greater awareness of the importance of access to justice, engage our supporters by building communities of stakeholders across the country and recruiting new advocates from many sectors of our country. It's particularly apt that LSC's first anniversary year forum is being held here in Texas. President Lyndon Johnson's Great Society and War on Poverty established the Office of Economic Opportunity that paved the way for the Legal Services Corporation. And its director, Sergeant Shriver, laid out both the rationale for and trajectory of what would become the Legal Services Corporation in remarks to the American Bar Association given in 1965. And I quote him, "The extension of legal services to the poor is only a means of a more universal end, one we both share, the establishment of the rule of law," he added. And he went on, "It is that ordered quest for dignity, for justice, and for opportunity that is a central concern of society today." Well, for 50 years, LSC funded civil legal aid organizations all across this country have pursued this ordered quest for justice. And as we recognize this milestone anniversary, we will redouble our commitment and our efforts to protect the promise of equal justice and make it a lived reality for all Americans. Thank you very much. It is now my great honor and real personal pleasure to introduce my friend, the very distinguished Nathan Hecht, 27th Chief Justice of the Supreme Court of Texas. Chief Justice Hecht has been elected to the Supreme Court 7 times, beginning in 1988 as a justice, and most recently in 2014 and 2020 as Chief Justice. Well, Chief Justice Hecht is the longest serving member of the court in Texas history and the longest tenured judge in active service. Due to term limits, he is currently serving his last year on the bench. Well, Chief Justice Hecht is a longtime, tremendous voice and advocate for access to justice. He's been a strong leader in helping courts around the country identify new and innovative practices for delivering justice. He's been a tireless, highly effective supporter of public funding for civil legal aid, both here in Texas and nationally. We at LSC could not be more grateful for his contributions to the field of access to justice and for his extraordinary leadership in helping to narrow the nation's justice gap. Please join me in welcoming the remarkable Chief Justice.
Thanks very much. Thanks, John. Welcome to Texas. Last Tuesday evening, it was 11 at my house when I went to bed, and 36 hours later, it was 81 when I left the courthouse. So if you don't like this weather, stay around a little bit, and it'll probably change. We're glad to have you here, and particularly the cause that brings you here. We're pleased with the efforts that have been made by so many people in the audience, by our Access to Justice Commission, the Foundation, leaders in the bar, for many years to strengthen the cause of access to justice in Texas. It was already a priority when I came to the court 35 years ago. Bill Whitehurst and I were talking earlier about IOTA being in its beginning years, and the efforts that were being made back then to try to push forward access to justice. And we didn't really, I mean, when I look back on that period of time, I think we knew the problem was big. It was big back then, but we didn't have a very strategic way of approaching it. We were just trying to do the best we could with every resource we could glom onto. We worked through the bar, and the bar's always been very supportive. And then 15 or 20 years ago, we began to look at ways that we could make a bigger difference. As John says, and there's no denying this, the justice gap is huge, and it's an embarrassment to the justice system in the United States that it's as big as it is. But we continue to work on it, and we've done made some progress in Texas. Frankly, we divide up on our court the administrative responsibilities that we all have, that the court has, and ask one of our justices to be in charge of it. For a long time, I was the liaison for access to justice. Now, Justice Brett Busby, who my colleague, is in that role. But in my experience in that position, it seemed to me that the biggest enemy of access to justice is abstraction. It's amazing to me. I guess it's just my own background and immersion in the issues that seems like other people ought to think the same way. But it's amazing to me how little is known about the reality of the justice gap. And it's not pretty much, it's not ideological. It's not a policy choice that's been made. It's just kind of dies for lack of a second. And almost always when you put a face on access to justice, when you actually bring somebody in and have them tell their story, then it persuades a lot of people. I remember years ago, we asked a client to come in and testify or give statements. She didn't really testify before the legislature during a recess. And she talked about how access to justice saved her life. And she turned to me while I was standing there and said, "You go tell the judges on your court, they saved my life." Well, what are you going to do when somebody says that? It's very powerful and helps to help people understand the importance of it and why we all work so hard at it. It also requires something that we're not very good at these days. We're into fighting these days. The bigger the club, the better. And not into evangelism. If you don't like a religious word, then persuasion. We're not good at either one of them. We kind of rather fight on the issues than actually try to convince somebody of something else or be convinced. And so as we have done that with our policymakers in Texas, we have found a very good reception. And it always helps to personalize it. I remember one trip we made to Congress trying to get support for LSC funding. And I was going around with Harry Reasoner, who was managing partner of Vincent Elkins at the time. And we were meeting with a congresswoman who was very, very, very skeptical. And she finally just blurted out, "There's a fella in my district that needs a lawyer. What are you going to do about it?" And Harry, without missing a beat, pulled his card out of his pocket and said, "Here's my card. I'll represent him, or I'll get a legal aid lawyer to represent him." And she's been a supporter ever since. That seems like a small thing, but it made a big difference to her because she was able to see through that, how important it was, not just to us as lawyers, but as advocates for legal aid. The House Appropriations Chair back in those days told me one time, he said, "You show me a used car dealer who cares about access to justice, and I'll be for it." He says, "This is a lawyer thing, and people just don't care that much." And he said, "If you really want to make a difference, you'll go out and make sure it's not just a lawyer thing." Well, comes along LSC with their leadership council, and they're out trying to take the message of the importance of the justice gap to a lot of other people who are not in the legal profession. I was in a meeting of the American Academy of Arts and Sciences years ago, and there were a bunch of doctors sitting behind me, and they were listening to a presentation by the Chief Judge of New York about the importance of access to justice. And there were 6 or 7 of them. They were all older, probably 60s, 70s. And I could hear them whispering. They said, we just had no idea. I had no idea this was the case. And then the second thing they said while I was eavesdropping was, why do the lawyers let it get like that? Well, why indeed? It's not for a lot of work on the part of so many people that are here. It's not for one of initiation, trying to find out better ways to do it. We're experimenting with kiosks here. Other states are doing that, trying to figure out better ways to train lawyers, better ways to meet with clients, all of that kind of stuff, all of innovation to try to make the offer of legal services easier and more effective and not political. So we have, you may have heard, a fairly conservative legislature. No chuckles there, as I thought there might be. But we have been, access to justice efforts have been strongly supported by leaders in the legislature and the executive branch on both sides of the political aisle for years and years. And I think when I go over there all the time on these issues, I just don't sense any kind of political view of this as, oh, well, here, this is on this side or this is on this side. We should take, it should be more political. It's just, I just really don't see any of that. We have a fairly conservative lieutenant governor, Dan Patrick, and he's president of the Senate and pretty much in charge of finances over there. They have a structure, but he has a lot of say in it. I went over a couple of years ago to ask him for legal aid for veterans. And he said, "Oh yeah, we're going to get that. We're going to get that done. Thank you. Thanks. Thank you for thinking of that. That's why you're such a great chief." I don't know about that. And then the amended budget comes out, zero in the budget. The final budget comes out, zero in the budget. I went over to talk to him. Randy knows the story, and I said, "Governor, I thought we were going to do this time." And he said, "You've been around long enough. You don't get everything the first time you ask. It's a good idea. You'll be back. We'll get it done one of these days. Don't worry." Went back to my chambers, feeling pretty low. 2 hours later, an amended budget came out, $3 million for legal aid for veterans. So I told him I would tell that story every chance I got, and add that it's better to be lieutenant governor than chief justice, but everybody probably knows that. And then a couple of sessions ago, Governor Abbott said, well, $3 million is not nearly enough. We should double that. So it's very nice to have, in the environment that we do a lot of other work in, it's kind of mainstay support for the efforts that we have been making and have them be perceived that way. Now, it's not enough. So shamefully, it's not enough. And so it's kind of hard to brag about something that still falls so short. But I do think the efforts, we have to keep making the efforts and make the progress that we can. And I know you all think that as well. It's a righteous cause. It's humanitarian, of course, but it's very patriotic too. And it's very ennobling because it protects one of the deepest values of our society, which is justice. I was at the 40th anniversary, and I thought it was great. And I wasn't thinking as I was sitting there, I wonder what the 50th anniversary will be like. And if I had been, I'd missed my guess because I wouldn't have anticipated COVID or so many of the things that have happened in the meantime. But through all of those efforts, the work to enhance and build access to justice have continued. I'm so glad that you're a part of it. It's an honor for me to be here. Welcome to Texas.
Thank you so much, Justice Heck, for your words and your years of service and partnership with the legal aid community in Texas and around the country, and particularly for your partnership with LSC. We really, really appreciate it. I'd like to introduce Cindy Tisdale, who will be leading our first of two panel discussions today with leaders in the field of domestic violence. Cindy is a partner at Goranson Bain Osley PLLC in Granbury, Texas. I hope I said that right. And of counsel with Lynch Chappell and Alsop in Midland. And she's done family law her entire career, in particular divorce and custody. It's a really tough area, so we appreciate that dedication. After serving in just about every possible role with the State Bar, Cindy is currently the president of the State Bar of Texas, and she earned her JD from Baylor Law School. So let's welcome Cindy to the stage, and she will introduce the panel.
So I would like to go ahead and introduce the panelists we have today. We have Maisha Coulter. If you'd come on up, there she is. She has been a CEO of the Aid to Victims of Domestic Violence since 2019. As a social worker and attorney, she has dedicated her professional life to advocating for the needs of children and families in crisis. So help me welcome Maisha Coulter, please. Next, we have the Honorable Dipal Malhotra. If you could come on up, please. She's a judge of Travis County Court at Law 4, where she presided since 2019 over domestic violence cases. Judge Malhotra began her career at nonprofit agencies in California and Texas as an attorney, providing legal representation for people seeking protective orders. She later served in the county and district attorney's offices. Please help me welcome Judge Malhotra. Sonia Lopez serves as the Director of Innovative Programming at Lone Star Legal Aid, overseeing the Crimes Victims Unit, Military and Veterans Unit, Grants Management Department, and various special projects. Pretty much everything I think I mentioned. Notably, Sonia played a pivotal role in the establishment of the Texas Crime Victim Legal Assistance Network. Please help me welcome Sonia Lopez. And last but certainly not least, we have Emily Dawn Whitehurst. She is only the fourth person to lead Houston Area Women's Center in its nearly 45-year history. She has spent her career championing human rights and addressing poverty, homelessness, and abuse. Help me welcome Emily Whitehurst. So before we get started on some questions with the panel, and yes, I have my phone up here so I can time them and cut them off if need be. I apologize in advance. But I want to kind of give some context and background on a few things. In 2019, the Centers for Disease Control and Prevention reported that about 1 in 4 women and nearly 1 in 10 men experience contact sexual violence, physical violence, and or stalking by an intimate partner during their lifetime. From the 2019 book, No Visible Bruises, What We Don't Know About Domestic Violence Can Kill Us, by Rachel Louise Snyder, it stated that domestic violence, health, and medical costs top more than $8 billion with a B annually for taxpayers and cause victims to lose more than 8 million workdays. Domestic violence is a direct cause of homelessness for more than half of our homeless women and is overall the third leading cause of homelessness in our country. Domestic violence and gun violence are deeply connected. There's a case right now at the U.S. Supreme Court, United States versus Rahimi. It's a pending case regarding the Second Amendment to the United States Constitution and whether it confers the government's ability to prohibit firearm possession by a person with a domestic violence restraining order. Mr. Rahimi was convicted of possessing a gun while subject to a domestic violence restraining order issued after he had violently assaulted his domestic partner in a parking lot and shot a gun when he noticed that others were watching him. Mr. Rahimi challenged the law as a violation of the Second Amendment to right to bear arms. That case, they had oral arguments last fall, and it's up with the Supreme Court now. But this is not just a Texas issue. Everytown for Gun Safety suggests that 2/3 of women killed by an intimate partner are killed with a gun. Access to a gun makes it 5 times more likely that a woman will die at the hands of her domestic abuser. So why are we here? LSC's most recent Justice Gap study found that the rate of intimate partner violence for women is nearly 3 times higher among those in the lowest income quartile versus those in the highest. 29% of low-income people seeking legal assistance were related to domestic violence, yet only 88% did not receive any help or enough legal help. Civil legal aid providers and partner organizations, of course, play a crucial role in interrupting further incidents of violence. Legal aid attorneys counsel victims. They locate safer environments for them and their children. They secure temporary and/or permanent civil protection orders from the courts and many other types of help, which make a huge difference in the life trajectory of survivors of domestic violence. So, Maisha, you're first up. Data suggests that low-income women experience 3 times the rate of domestic violence than women in the highest income quartile. Any external factors that add to that stress, isolation, or financial strain can create circumstances where survivors' safety is further compromised. Can you tell us who is and how many people are seeking services? And then I want you to follow up with how did this change because of the pandemic?
Sure. Good morning, and thank you for allowing me to be present today. One of the things that you said is absolutely true, that low-income women will experience domestic violence at a higher rate. But make no mistake, domestic violence is not a respect of persons. It does impact everyone, socioeconomic status or culture and ethnicity. Those things do not matter. But what does matter is those who are encountering domestic violence who are in marginalized communities, whether they be low income, immigrants. The problems tend to be that domestic violence festers in a climate of fear and shame. And certainly when you are a undocumented person who might be experiencing domestic violence, you're hesitant to pursue the traditional avenues for resources, whether that be police, social resources, or the criminal justice system. And those are the barriers that a lot of our constituents face. The majority of the clients that we see mirror the population of Harris County in regard to who is coming to get the services that we provide. But what we do find is that hesitancy around who they are. So, for example, if you have an African-American client who comes to us, one of the things that we hear anecdotally is that they are afraid to expose their abusive partner, not only because of what might happen to them as a result of that exposure by the partner, but what might happen to that person if they encounter the police as a result of a call to get relief and help. And so they actually make those contemplations when they are deciding whether or not they should help themselves or help the person who is harming them. And that is something that we really need to be more acutely aware of as we provide the services. We need to be sensitive to the cultural and ethnicity of those who need the help that we're providing. And certainly because those people are the most likely going to be the ones that will receive legal aid services across our state. So we need to really be trauma-informed and contemplative of the barriers that exceed the barriers of being a person who is being harmed by someone who claims to love them or who is their intimate partner.
Thank you. Sonia, I kind of want to build on that, if you would, please. Could you share a client story that paints kind of a more complete picture of someone that's seeking assistance due to domestic violence?
Absolutely. Thank you for having me on the panel.
You might want to move the microphone a little bit closer to you.
A little bit closer? Is that better? Thank you for having me on this panel. And I can reiterate what Misha is saying. Domestic violence has no boundaries, and it impacts individuals from all walks of life. I'll go ahead and share Gloria's story. Is that better, Andy? So Gloria had been married for roughly 4 years. She was undocumented, and suffered physical abuse at the hands of her husband. After about 2 years of being married, he started to ask her to leave the home. This being despite the fact that she had just found out she was pregnant with their first child. He asked her to leave. She didn't have anywhere to go. She didn't have a support system, so she stayed. The abuse continued. She was afraid to call the authorities because her husband would remind her of her immigration status. She didn't know what would happen. She knew, however, she needed to get away when their then 2-year-old daughter started showing her how daddy was touching her. Gloria started asking questions about the incident. Her mother-in-law, who was a mandatory reporter, told her, go to the hospital, figure out what's happening. This is when she got connected to services that she didn't even know existed. She was contacted by CPS. She was connected to the Houston Area Women's Center for Support Services. She was then also connected to AVDA, AIDS to Victims of Domestic Violence, for assistance with a protective order. She finally found what was there and services that she was able to connect to and what could possibly happen to her. AVDA helped Gloria obtain a protective order for her and her daughter. But her husband, an educated man and someone who had the financial means, filed a divorce action and also appealed the protective order decision. Gloria was again feeling helpless. She was concerned that she couldn't protect her daughter from her abuser. AVDA referred Gloria to the Texas Crime Victim Legal Assistance Network, to Lone Star. And through the appellate process, Lone Star was able to uphold that court's decision. And Gloria today and her daughter are protected. In a similar case, Lone Star was representing a survivor who fled her homeland to escape her abusive spouse. The Houston Area Women's Center opened their doors while Lone Star was able to proceed with their legal case and was able to keep this family united. Justice again prevailed. This collaborative approach among local providers and the community has helped transform us, these local providers, into a beacon of hope for survivors who need us.
Thank you so much. Emily, you're up next.
Yes,
In
ma'am.
my introduction, I talked a little bit about the Rahimi case. Can you talk to us about the correlation between domestic violence and guns and kind of what we need to understand about that?
Absolutely. So you mentioned that having a gun in a home makes the lethality rate there 5 times as much. But I'd like to contextualize what's happening here in Houston for you. In the last 3 years, we have seen a doubling in domestic violence homicides. And 73% of domestic violence homicides here in the Houston region are due to gun violence. About just shy of 1 out of 5 homicides in the Houston area are domestic violence related, and 1 out of all 10 crimes reported to HPD are domestic violence related. What I'd like for you to think about is what it would feel like to be one of our hotline call responders. We have trained advocates on the hotline, and in the wake of the pandemic, the calls to our hotline have shot through the roof. We manage over 50,000 calls a year. And when people call us, we do a lethality assessment if it looks like that's required, and many, many times it is. And that lethality assessment helps us determine how dangerous the situation is. And one of the most important questions we ask is if there is a gun in the home. In the Houston area, even when we know someone is in lethal danger based on this data-driven tool that we use, this assessment tool, we have to turn over half of those callers away because we do not have sufficient emergency supportive housing. So you can imagine our outrage and alarm when this Rahimi case came forward, because the fact that we are debating whether somebody has a constitutional right to a gun when we are on the front lines of trying to save women and children, mostly who are being stalked and terrorized, is it's just unconscionable. We were thankful to partner with Yetter Coleman and put together an amicus brief. The Houston Area Women's Center submitted a brief to the Supreme Court. I would love for y'all all to read it. I'll send you a link if you contact me. And we also did a change.org petition. So we've got 8,000 signatures saying, no, somebody should not have access to a constitutional right to a gun if they're subject to a protective order and have a record of domestic violence. So I hope y'all agree. I see some nodding heads. We really, really have an issue here. And when you're on the front lines of those calls, the other thing that you know, which I really want people to hear today, is those domestic violence abusers who have guns are often very overrepresented in mass shooting suspects. Some indications say 68% of mass shootings are perpetrated by people who have a record of domestic violence. So our callers are, I believe, not only just saving lives, but preventing mass shootings and trying to reduce the homicide rate here in the Houston area. I look forward to collaborating with y'all on making sure that we do not see a continued rollback in these vital life-saving protections that we depend on.
Thank you so much. Judge Malhotra, you've heard your three co-panelists, their discussions. Can you tell the audience how you compare that to what you see from the bench in Travis County, number one, and then how does survivors' access to representation affect the outcome?
Well, first of all, good afternoon, everyone. It is such a pleasure to be here today and to share this stage with these incredible women. I think every jurisdiction probably is seeing the same trends. We've seen an increase in domestic violence every year. We've seen an increase in requests for protective orders. Travis County is no exception. And we've also seen an increase in homicides related to firearms. Just so you all know, just to follow up on some of the statistics that were already given, in 2022, in Texas, 216 people were murdered by intimate partners, over 70% of them with firearms. Travis County, in 2022, we had 8 intimate partner homicides, and 6 out of the 8 were committed using a firearm. And so we know that the risk of lethality increases by 1,000% when the abuser has access to firearms. So this is something that is extremely important to me sitting on the bench, and it's something that I have to be cognizant of in every decision that I make. Primarily, the decisions that I make are, if I'm letting out someone on a personal bond, or if they are out on a surety bond or anything like that, I need to make sure that there are conditions that are in place in order to obviously preserve the community's safety as well as the survivor's safety. So we're talking about GPS monitors installed in jail, not outside of jail, stay away orders, no contact orders, and specifically with respect to firearms, making orders that disallow abusers from having possession of firearms when they're out on bond. And if there's any indication to the court at all that there has been a history of gun violence, or even, this particular person had ownership of a gun at some point during the relationship, I always make a relinquishment or a surrender order. They must relinquish within this amount of time, give them very specific directions, and then they have to provide a receipt of relinquishment to the court and to pretrial services. And so and this kind of segues into, I think, the second question you were asking, which is legal representation and how that impacts survivors of domestic violence. We know that the number one deterrent for people leaving abusive relationships is lack of legal services. We know how daunting it is to leave an abusive relationship. We also know that it takes, on average, 7 times before a person is able to leave an abusive relationship. And so once they get away from the abuser, can you imagine if they have children together, if they've been dependent on that person financially, and then trying to expect this person to navigate the legal system and its complexities by themselves. I'm really fortunate in that I preside over a specialized domestic violence court. So I hear upwards of 3,000 misdemeanor domestic violence cases every year, as well as I dedicate one day a week to protective orders, civil protective orders. And so the few times that we do have someone who's not represented by the Travis County Attorney's Office, it's heartbreaking because you can see the level of fear, the intimidation that person feels. Our legal system is not user-friendly. It's very complex. It is not always culturally competent. And it is not always trauma-informed. But when you have a specialized court, and for those of you who come from jurisdictions where you don't have that luxury, I really think you should be talking about that in your jurisdictions, because we have the ability in these specialized courts to provide safety resources. One example I'll give you, and please feel free to cut me off, but one example I'll give you is that, for protective order dockets, we have bailiffs who come in, we have law enforcement officers who are there to escort people to and from court. We have extra officers in the courtroom. We know, that all of this leads to better outcomes as far as offender accountability and victim safety. So I could really go on, but I think you get the idea.
Don't make me have to stop you, Judge. I don't want to be put in that position. Sonia, as Judge Malhotra just said, navigating the legal system, as we all can imagine, is daunting if you're doing it alone. Can you tell the audience what the process is for accessing legal services through Lone Star Legal Aid and other legal service providers, and what you provide to those domestic violence survivors?
Absolutely. A survivor usually can start their journey to obtaining legal assistance by either calling a hotline, and the support service organization will connect them to legal services, or they've been referred by law enforcement agencies, sometimes like the judiciary as well, and also by private bar attorneys who can't take on their cases and they say, you need to go to legal aid. But many times it's also just a request for services directly to legal providers. A lot of times we have to do our own awareness into the community, make sure that they know what we're doing, what kind of services we can provide. In addition, it's kind of just educating the social service agencies. They might be very well attuned to helping someone and counseling them, but they don't know all the services. They don't know exactly what legal aid does. So it's getting out into the communities, not just to the survivors, not just to the community, but the actual social service agencies, and letting them know what exists and how we're able to provide services that we do. Lone Star has several crime survivor projects in itself that just target specific communities, survivor communities. We specialize in reaching veterans, sexual assault survivor communities, and social service agencies, elder abuse, and human trafficking. And this is in addition to the already general outreach that we promote. Also, we just want to get a survivor connected to legal services as soon as possible so that they know their legal options. A lot of times when they need maybe resources financially, like the judge mentioned, we can get them public benefits, disability, SNAP benefits, emergency SNAP benefits, because the sole income provider is no longer in the home. We can also promote safe and stable housing. That's promoting, preventing foreclosures, evictions, maybe even clearing title. Sometimes we've seen cases where ownership of the property is being put in a child's name just to make sure the spouse isn't going to have access to the property. We can also help with crime victim compensation packages from the state. We can help with remedies for coerced debt, also enforcing child support, also getting child support and obtaining it, spousal support, IRS on earned income credits, tax debt that's sometimes for innocent spouse provisions. I mean, there's just a plethora of services that we can provide. We can also help with obtaining health care. Sometimes we've found that they're eligible for Medicaid, or it's that they are eligible for indigent programs within the county. It's also that sometimes the abuser has decided not to put the family on their medical plan, so we can try to enforce those things. There's also your general divorce and custody, but also educational services. Sometimes these families are dealing with children that need more in the educational system and they need services. So it's attending ARD meetings, IEPs, immigration services with T visas, U visas, and I can keep going on, but also environmental justice to preserve home valuations, when in turn is going to preserve generational wealth. And let me not forget, here in Texas, we help with disaster relief. So I know that sometimes when disasters are happening, sometimes abuse actually goes up. Those statistics go up. I mean, we heard about it during COVID. So it's really important that getting survivors to legal aid and legal providers can actually, it's just important so that they know what is next, what decisions to make. As far as support, Lone Star Legal Aid has tried to ease that burden. You heard me mention earlier the Texas Crime Victim Legal Assistance Network, and that's basically a network that helps bridge the gap between criminal and the civil justice systems. And basically it's putting law enforcement and the social service agencies together by using a portal, and you can actually refer a survivor to multiple services at one time. And it's basically putting the onus of finding services on the network and not the survivor. As additional support, Lone Star has a social worker on staff, which is kind of unique for a legal aid program, but we have found it's very, very helpful, especially when someone is dealing with, their legal case and then also with the criminal justice system at the same time. So when you talk about daunting, they have two systems that they've probably sometimes never been aware of, and this social worker has definitely played a vital role in helping them in their recovery. In addition, we've provided extensive training to our staff so that there's sensitive survivor interviews and we can actually meet survivors where they're at. You can have a survivor that has been victimized for the first time, or you can have somebody that's been victimized for years and has finally decided to go ahead and make a change and get to a safer future. So I think we try to empower survivors with the legal tools and support so they can break free from their abusive situations and hopefully find that safer future.
Thank you. Emily, the theme of the most recent Domestic Violence Awareness Month back in October was Everyone Knows Someone. And just the title of that alone shows how pervasive it is in our society. Given the scale of that, there's no single organization that can do it all. So can you tell us how the Houston Women's Area Center is collaborating with community partners here in Houston?
Absolutely. So as you've heard, we partner very closely with Lone Star Legal Aid and ABDA to try and braid together all of the resources and help coordinate that on behalf of survivors who are often and understandably traumatized and overwhelmed. One of the interesting partnerships that we're really proud of here at the Houston Area Women's Center is one with the Houston Police Department. They have a domestic abuse response team where they send out police officers with crime victim advocates and oftentimes healthcare professionals. And in the event that when they go on site, they can determine that this person is in imminent danger, they will bring them directly to our campus. And on our campus, whether they're stay for a week or for 45 days, which is our average stay, or longer, we've had residents with serious legal security needs stay maybe even up to 2 years. We're able to work with them to provide over the long term free counseling and behavioral health services, housing, financial coaching and empowerment, and of course the partnership with legal services. I think the other piece I want to just talk about in terms of collaboration and coordination is making sure that people, that includes you, understand the concept of safety planning. Safety planning is probably one of the most important things that we do, but look to everybody in theory to help do. And some of the things you need to know are leaving is in fact the most dangerous time. So if everyone knows someone, and intuitively people might think, well, if it's not a safe space, get out. The truth is that may be the worst advice to give unless that person has a safety plan. So doing public information campaigns is a big piece of what we do at the Houston Area Women's Center so that people know that that leaving can be extremely dangerous and that there are key things they can do to put in place to make that leaving safer, especially when it comes to electronics. Technology has changed the game for people trying to flee, and certainly getting all their documents together. That can be so helpful if, in fact, they do need legal services. So safety planning and a collective coordinated response. One of the most meaningful partnerships we have in this is with the East End Funeral Home that truly sees the value of safety planning and has helped underwrite this campaign. So that's a kind of an interesting type of collaboration. But there's so many different ways that people can plug in to supporting survivors' overall journey to recovery in the wake of harm.
Thank you. Maisha, as we know, domestic violence is multidimensional. And so I think we have to look at our response to domestic violence must also be multidimensional. In addition to working with survivors, ABDA provides educational services to men and women who have been violent or abusive or controlling to their intimate partner. Can you tell us what have you found that's most effective in breaking that cycle of violence?
Sure. Sonia said something just now in that it's the most dangerous time for a survivor when they are leaving. And oftentimes we do ask the question, why is this person staying in this relationship? But the more critical question that doesn't get asked often enough is why is the person perpetrating this level of abuse to the person who they claim to love? And that is something that we consider greatly at ABDA. We have the largest BIP, or Battering Intervention and Prevention program, in the state of Texas. And that is an opportunity for those who've been identified as harm doers in their relationship to get psychoeducation and to really think about and be held accountable for the behavior that got them referred to us in the first place. Oftentimes we find, though, that those who are harm doers in the relationship are also survivors themselves. They grew up in homes where domestic violence was perpetrated by their parents, and they thought that that was the way to behave in a relationship and knew nothing different. And until they have been confronted by other ways to address whatever it is that is motivating them to make those decisions, they don't change. And so this is an opportunity for them to encounter a different way to think. We are with the people who are referred to us for a minimum of 18 weeks. And our facilitators are mental health professionals, LPCs, licensed clinical social workers, psychologists, and they work with them and they retool them in ways that they say, those who have actually completed programs say, made them think totally different about their relationship, about their behavior, about their family, and about their future and the future of their children, oftentimes. So we think that it is one of the things that we should be considering more. But in addition to that, the other thing that is critical is prevention. And we don't do enough of that. I remember, growing up, we all had a health class, in high school or, at some point in our education. We don't have healthy relationship classes. We don't educate children about what is appropriate behavior or what is accountability. And that is something that we've taken on at ABDA and other places here in Harris County and in the greater Houston community, is helping young people to think about relationships in a way that is intentional. We have a number of evidence-based programs that we provide by way of curriculum to HISD, Fort Bend ISD, and other greater educational systems. And that, we believe, is much more of a lift to all of us, so that if our children in the future, people respond differently, then we will see these numbers come down. But until that happens, we really do have to hold people accountable. And we, as a society, this is a public health crisis. It is impacting all of us. These people have children. They go to school with your children. They are encountering the criminal justice system. They are in the workplace or not in the workplace because they are experiencing domestic violence. So you're feeling it. You don't necessarily know that you're feeling it. But when you start to understand the reverberation of domestic violence, you can play a part in trying to curb it societally, and to really think about a different approach, and to really stop engaging in this sort of victim blaming attitude that, has been around forever. And I don't think that people do it on purpose. You want people to be safe. But that mindset, unfortunately, is probably supporting us not having the types of solutions that ultimately will have the impact that we want to see. We want these numbers to go down. That's the end game. Maybe even go away altogether, right?
Yes, absolutely. Can we have an amen? Judge, I want to talk to you for a minute. We know you're a judge now, but your path to being judge has included work at nonprofit agencies, being the chief prosecutor in the family violence unit in Travis County. Can you tell us kind of how your past experiences have influenced your judicial approach to domestic violence?
Sure. And one thing that I will share with you all, and I have been pretty open about, is I was exposed to domestic violence as a young child. And so I think because of my experiences, I was just so in tune with some of the, the dynamics that we see with domestic violence. We talk about, every day in my courtroom, or every week rather, we have jury trials, and we're educating, the state and the defense are educating jurors about this issue. And you would be amazed at how many people still have those very common myths and misperceptions about domestic violence. Just some of the things that Maisha even talked about. Why does she stay? Why doesn't she leave? I don't understand. I would be out of there in 2 seconds. And so my experience, has really led me to be very passionate about this work. I understand the dynamics and the nuances that are so complex in these cases. And I think that that allows me to better serve the community. I know as a prosecutor, when I first came into the Travis County Attorney's Office, and I remember looking at all the cases that we had and looking at the previous dispositions, and most of these cases were either reduced or they were dismissed. And I started looking at why. Well, we had an affidavit of non-prosecution, which is basically, you know, the victim came in and said, it didn't happen, I'm crazy, I made it up, I lied. And so, you know, my first job and the first thing that I wanted to prioritize was teaching my team about these dynamics. And I think everybody who works in this field has to understand the nuances in these cases. I really would suggest that everyone do a 40-hour training, but I know that's not easy to do. But really, you have to learn what these dynamics are in order to better serve our community. And so that's the first thing that I did. Learn what's happening so that you can understand how to be more trauma informed. And you can understand when a victim says, you know what, I don't want to go forward. And what do you do at that point? And we have the legal resources. We have statutes in place. We have laws in place. You all know this, that will allow us to prosecute these cases and hold offenders accountable even without the victim's participation, but we don't do it enough. And so, you know, I think, and then moving on to now being a judge, just my experience both as a prosecutor, both working at a nonprofit prior to that as a staff attorney, and then of course my personal experience have allowed me to create a courtroom that takes into account the safety issues that are at play. You know, we have, as I mentioned before, we have the protective order docket, and we do have safeguards in place. We have advocates who come to our courtroom. I want to make sure that I'm not missing anything. One of the things, you know, I want to go back to collaboration and coordination and why we're here today. You know, when we're talking about firearms and things like that, things that we're very concerned about with respect to these cases, it is so critical to have folks representing survivors in court, because when you have a specialized court and you have a judge who understands the dynamics of domestic violence, that's one thing. But most jurisdictions don't have that. And so you don't know what you're sending that survivor into. It could be a courtroom where a judge has no clue what is happening. I remember practicing as a staff attorney at a shelter back in the Bay Area years and years ago, and walking into a courtroom with someone, and my client, who was a survivor, was very upset, hysterical. She saw the other party there. And let's not forget that batterers weaponize the legal system to intimidate, to threaten survivors, and to ensure that they won't seek legal protections. And I remember the judge, and I will never forget this, the judge said, "Why are you so hysterical?" And, you know, and so for me, I just, you know, of course, at that time, I never thought in a million years I'd be presiding over a domestic violence court. But for me, every day, it is so important that any approach that I take on any case is trauma informed. And again, I have to also say this as well. My personal experience also allowed me to understand that change can happen, that people can change. But as Maisha said earlier, you know, we have to give them the tools to be able to do that. So these batterer intervention programs are critical in allowing people to unlearn unhealthy behaviors and to relearn how to engage with someone in a healthy relationship and a healthy dynamic. So.
Thank you, Judge. Talking about people changing, we're going to kind of finish this out. You know, we've all made clear that access to legal services can have the long-term impact on survivors, on their families, on communities. So Maisha, Sonia, and Emily, and only them because you don't have clients at this time, Judge, but could the three of you just have 1 minute each with a quick client story that illustrates the benefits, how they help these survivors, and kind of give us a hopeful and helpful outlook for this?
Sure. So I'll quickly say this. I've been with ABDA in total 17 years, so I have too many client stories in my head. But I do want to say that I know that what we do changes people's lives because the clients tell us daily. They tell us. They tell us through letters. They tell us through pictures that they send to us with their children, going to school, engaging in activities that they would not have been able to do had we not secured, superior rights between them and their partner who did use the legal system to abuse them continuously. So what I want to say more importantly is that you all have a role to play. Anyone who is supporting Legal Services Corps and trying to make sure that we have the resources to do this work, do everything you can in your power to make sure that the resources continue to be there and that they do grow, because the problem is not going away, but there are people whose lives are on the line. Again, thousands of people we've helped over the years. It would make no sense for me to pick out just one, but trust me when I say that they are there and they are changed forever, but they cannot be without these resources. They have no other places to go if these resources are not available.
Thank you, Maisha. Sonia?
I think one of the most important things we do when we meet survivors is definitely continuing to keep them housed. I think having a roof over your head is super important, especially when you have young children and don't know where to go, when you might be undocumented or very low income, and it's where do you go to actually, get another apartment when the sole provider is now gone, or you just don't have the rental income or the wages that you might have needed to get that rental on your own. So I think when we're actually trying to enforce these rights for our clients and we say, no, this is the exclusive primary residence for the family that's been abused, I think that's very important. And I think it goes long term so that they can actually know where they're going to raise their children, continue to keep that roof over their head for stability, and then their education. I just think it just flows down. So if I had to say anything, it's not one client story, but it's absolutely trying to just preserve homes.
Thank you. Emily?
Okay, I'll end with a quote from a client who received services at Hawk. I'm grateful for Hawk. The program provided everything I needed to get things on track. I am now a licensed professional, able to provide my own lifestyle. If it wasn't for the Hawk program, I would not have made it free from my abuser's financial and physical abuse. I am ever grateful for my case manager. She has the heart and knowledge to help those in need. I know that I am able to help someone else understand that you can be free from abuse and able to make it on your own. Thank you, Hawk, for everything. So the greatest privilege we have working at these organizations is we see how investing in these services really does save lives and make a difference. And that's such an important point of view to bring to the table, because if you're just watching the news, it can feel so demoralizing and there's nothing can be done. But the truth is, if you give survivors the support and resources, they can establish life free from violence.
And with that, we're going to end. I wish everybody to please thank our wonderful panel here for their work.
She's a member of the House Committee on Energy and Commerce. Representative Flesher is one of the 12 members of Congress appointed to the Regional Leadership Conference. She is, for which we are most grateful, a stalwart supporter of LSC. She's a member of the Bipartisan Access to Legal Aid Caucus. She signed the annual Dear Colleague letter in support of LSC funding every year. Thank you for your service and thank you for joining us here today.
Thank you so much, Lori, for that lovely introduction. And thank you to everyone at the Legal Services Corporation for inviting me to join you here today and to share a few thoughts for a few minutes. I really am thrilled to be here in a room full of my people. I would describe you as my people, and a room full of people who know how important having good lawyers is and good advocates is in the pursuit of justice, and people who do so much for so many in our community. Today is a real milestone as we celebrate the 50th anniversary of the Legal Services Corporation and honor the work that it does, and that everybody who's assembled here and who's committed to this mission does to promote and ensure equal access to justice. I'm so pleased to be here with so many members of our own community and so many dignitaries who are here in Houston visiting with us for this special occasion as the first of a series of anniversary celebrations in 2024. And today we have leaders of our legal community who I see throughout the room who've assembled to support and further this mission. So I'm really just honored to be in your company and excited to share just a few thoughts with you. And I think today's lunch really emphasizes what I always tell people in Washington. I love to tell people how we do things in Houston, right? That we have a special community here that really thrives on partnership, that works together in a collaborative way to solve problems. And we really come together to help. And there's really no better example than the work of the people who are assembled here today. From my own days practicing law in Houston, as you heard, I spent about a dozen years here practicing law. And I know from personal firsthand experience that legal aid is a critical tool to expand access to justice for all. I had the privilege of representing many clients pro bono as part of my service, especially as a young lawyer at Vincent & Elkins, that really emphasized the importance of that program. But I got to represent so many people who needed access to the courts for things that were both essential and also elusive for them. Like one of my clients who I remember so well was a naturalized citizen who was seeking to change her name after her divorce from an abusive husband, and who connected with me through her volunteer literacy instructor. As she was learning to write her own name, she realized she didn't want to write the name of her abusive ex-husband. She wanted to write her own name, but that hadn't been handled in her divorce. And so she came to me, and I think a lot of people know here, name changes are sometimes hard to get, harder than they should be. And so I got to work with her on that and with her volunteer literacy instructor. And so since my first term in Congress, I have advocated for funding for the Legal Services Corporation. Most recently, I was happy to support the annual letter for funding for fiscal year 2023. I was very disappointed, as I'm sure you all are too, to see that the proposed cut in the proposed legislation, there's a proposed cut to Legal Services Corporation funding as we look ahead to fiscal year 2024. That said, Congress is still deciding the precise government funding levels, as I'm sure you all know from watching the news. We have not quite figured that out yet. And so I'm hopeful that this can be something that is addressed certainly this year and hopefully into the future, because we all know, everybody in this room knows that this proposed cut is going to affect hundreds of thousands of seniors and veterans and disabled persons and victims of domestic violence, survivors of domestic violence, who need the help that the Legal Services Corporation provides them to remain in their homes, to keep their families safe and access needed services, and just exercise their rights. So since I first took office in January of 2019, my office has worked here in our community in addition to on the legislative front in Washington. And I can tell you that we love to help people. We've closed more than 13,000 cases since January of 2019 in my office, but we can't help everyone. And we've referred more than 100 people to Lone Star Legal Aid for pressing problems that we can't help with. These are constituents facing eviction, immigration issues that we can't solve, and other matters. And they've sought help from volunteer lawyers in our community. And I'm so proud of the people who have helped them, who are so committed to justice and fairness in our legal system. And I think everyone in this room knows that we need more legal aid in Texas, not less, to achieve what is a founding principle of our country, equal justice under the law. Despite nearly 3 million hours in free legal services in Texas, 3 million hours that Texas lawyers have provided for low-income Texans in 2022 and 2023, that's fewer than 10% of the civil legal needs of low-income Texans are currently being met. It's just a staggering statistic, especially when you think about how many people have come together to do this work. And so I will continue to fight in Congress to make sure that Legal Services Corporation can get more funding, more support, and that we can really meet the mission of the Legal Services Corporation for increasing funding and increasing and expanding access to justice for all. For those who receive legal aid, the impact cannot be overstated. And I know that earlier today you had a panel on domestic violence. And I just want to note as well how important that is here in our community and across the country. As I mentioned earlier, I had the privilege of helping a domestic violence survivor who, in working to rebuild her life, who spoke English as a second language and was learning to read and write and wanting to learn to write her own name, needed volunteer legal services. In Texas, domestic violence touches every city, every neighborhood, and every community. The Texas Council on Family Violence estimates that 1 in 3 Texans will experience domestic violence in their lifetimes. Legal aid is one of the most important tools available to reduce domestic violence. One estimate from the ABA has shown that the chances of a victim of domestic violence obtaining a restraining order increase from 32% to 83% when a lawyer is present. It is absolutely critical that we work to ensure the safety of all families here in Texas and across the country, and there are many ways that we must work to do so. In Congress, I have worked to provide much needed support and help to survivors and help them rebuild their lives and stop abuse before it happens. I believe that later today you may be hearing from one of my colleagues from our Houston congressional delegation, and I was so proud to work with her and to be an original co-sponsor of and vote for the Violence Against Women Reauthorization Act, which President Biden signed into law in March of 2022. My colleague, Congresswoman Sheila Jackson Lee, has been an absolute champion on this issue, and she was there working on it the entire time she's been in Congress, and that's for 25 years. The Violence Against Women Act provided essential support services for survivors of domestic violence and sexual assault, and its reauthorization in 2022 was vitally important for our community here in Houston and communities across the country. In addition to reauthorizing VAWA, the bill made vital improvements to improve access to housing for survivors, to close the boyfriend loophole that exists in our gun purchase background check system. It helps survivors gain economic independence. And many of the improvements in the reauthorization bill that we just passed were things that we learned from survivors and their lawyers about the challenges that they face in court and in rebuilding their lives. Before its reauthorization, the Violence Against Women Act had provided $8 billion in grants to support services for survivors and to prevent domestic violence and sexual assault, and to investigate and prosecute abusers. And with its reauthorization, I'm pleased to report that those grant funds are coming again to the Houston area. Just in December of 2022, I was glad to announce that the Houston Area Women's Center, which is located in my district, would receive more than $800,000 for advocates to assist survivors during the legal process, including with protective orders and crime victim compensation. And I think it's really important, again, to go back to the partnership that we see across this room from advocates who play such important roles in every aspect of the lives of those who need access to justice and access to legal assistance. So we have to all continue to work together to address domestic violence in our communities, to address the challenges that people who don't have access to justice face. And I think on this issue of domestic violence and in every issue, we must work together to ensure that the core purpose of the Legal Services Corporation, ensuring access to justice for every American in every circumstance who needs legal assistance, remains the promise and the reality in America. So in closing, I just want to thank you all for all that you do to make this promise a reality. And I want to thank you so much for having me join you and share these thoughts today.
Good afternoon. Thank you, Congressman Fletcher, for taking time out of your demanding schedule to join the Texas legal community in their celebration of 50 years. My name is Maria Thomas Jones, and I'm the CEO of Legal Aid of Northwest Texas in the Fort Worth area. And it is my honor to introduce today our colleague, Jan Edgar Langby, today's keynote speaker. For 32 years, Jan has been an activist in efforts to end violence against women, currently serving as the CEO of Genesis Women's Shelter and Support based in Dallas, Texas. She is recognized as a national expert on the dynamics and effects of domestic violence and has spoken at numerous events locally, statewide, and at the national level. Jan provides expert testimony in court cases and trains law enforcement and prosecutorial professionals to enhance their efforts to end violence against women. And she has served as a presidential appointee and senior policy advisor to the director of the United States Department of Justice Office on Violence Against Women. We are so grateful for the opportunity to learn from her today. And she is a feisty advocate. She is a fabulous person, and she has trained thousands, if not tens of thousands, of people to be able to provide legal services and services altogether for survivors of domestic violence. And so I introduce my friend, Jan Langbein.
Good afternoon. It is such an honor to be here with you guys today. I'm probably, maybe the biggest fan of Legal Services Corporation and the work that you do, because at Genesis, I get to see firsthand the miracles that happen when there is civil legal representation. You know, as I stand here and I look around the room, I see men and women of leadership and accomplishment and achievement, but I really do feel that if we are to lead and achieve, then we must remove the roadblocks. We have the opportunity, but also the obligation to remove roadblocks that keep other people from leading and achieving. Roadblocks like poverty, roadblocks like homelessness and hopelessness, roadblocks like domestic violence. About 10 years ago, there was a movie called The Emperor's Club, starring actor Kevin Kline. He was a professor of classical literature at an all-boys preparatory school. And in one of the classes, he was talking about the reign of King Shutruk-Ahunte, who was king of the Elamites in 1500 BC. And there was even a plaque up there in the classroom talking about his great achievements and his conquests of lands and riches and wives. And he speaks of his great wealth. But the kids in the class, the young boys in the class, started talking about, if this guy is so famous and if he's so amazing, why have we never heard of him? And Mr. Hunter, the teacher, said, he answered this question with these words: great ambition and conquest without contribution is without significance. Great ambition and conquest without great contribution is without significance. And that's what I'm here today to talk to you all about. What is your significance? You come from all over Texas, all over the country, from different cultures, but by the very work you do, I can stand here and tell you that I know you're loyal, that you're compassionate, that you're thoughtful, that you're determined, and you are responsible. In the Declaration of Independence, it says liberty and justice for all. Not liberty and justice as long as you can pay $300 an hour. It's not liberty and justice as long as you don't vacillate back and forth between stopping and starting those proceedings all over again. It doesn't say liberty and justice. It says liberty and justice for all. Creating legal aid offices all across this country, you have been helping to provide that liberty and that justice, and I applaud you for that. But I also challenge you to do more, to be professionally and personally significant. So this work that you do, this work that you do cannot just be a stack of manila folders on your desk. It's not just the burdening number of cases that you have. This is what I mean. Let's say I walk into your office and I'm halfway in tears and I say to you, I need a divorce, but I don't know how to go about it. I don't know what to do next. I left my husband a week ago. I don't have any money. I have 3 children. What I'm not telling you, ladies and gentlemen, is last Saturday night, he put his hands around my throat and he was going to kill me. I don't know why he stopped. I don't know why he let go. I don't know why he let me live that night. But the truth is, he didn't want to kill me. He wanted to show that he could kill me at any time he wanted to. You know, I went to the police, but the color of my skin, because of the color of my skin, the bruises on my neck didn't show, but my hidden bruises were my dizziness and my fogginess and my headaches, and I had difficulty swallowing, and my speech was hoarse and gruff. But I kept hearing his words in my head. That's the hidden damage, is the words in his head that he said if I ever tried to leave him, he would hunt me down and he would kill me. So since that last week, Saturday night, I have felt invisible. I have felt unseen. I have felt unheard. I have been failed by systems that were meant to protect me, justice systems, and justice seems elusive at every single turn, from the hospital to the police station to court. So I'm going to ask you, will you be the one pulling me from this wreckage of domestic violence? You see, that changes everything for you guys. That changes everything about this divorce. That information that I just gave you changes what custody ought to look like and what separation ought to look like and what your safety concerns in your courtroom ought to look like. And by the way, I just want to tell you this. If there is just a check mark on your intake form, are you safe at home, or did your partner hurt you or hit you? I'm not going to check yes. I don't know who you are. I don't know if you can help me. I don't know if and I am terrified that he's going to keep that promise that he said he would hunt me down and kill me. Or he would go to court, like some of our panelists said earlier, he'd go to court with a suit and a tie on, and he'd look across from his hot and cold running legal team, defense team, and he would call me a drunk, and he would call me a whore, and he would say I'm unfit to be a parent, and I would lose my children. Because he told me it was my fault. He told me that if I cried less and smiled more, or if I could be a Proverbs 31 wife, that he would not have to treat me this way. See, this is all very critical information that you need to know as attorneys if you are going to help me. But with my case, what are you going to ask me, and how are you going to ask me, so that I don't just give you a flat no? I was speaking at grand rounds at a large area hospital in Dallas not long ago, and I was going through the dynamics of domestic violence, the cycle of violence, and all the things, the myths around it. And I asked them in this family medical clinic that they had that day, do you ask every patient? Because as they were saying earlier, 1 out of every 3 women in Texas will know domestic violence. Domestic violence is the leading cause of injury to women in the United States. Do you ask about that when you are checking me in? The nurse said, absolutely, absolutely. We ask everybody. But there's the weird thing, is nobody has said yes. And all the times we've been asking, not one person has said yes. And I'm like, okay, let's talk about that. She goes, I think it's weird that we don't have any survivors of domestic violence. I'm like, really? I think it's weird that you don't know that you have many survivors of domestic violence. But I said, when do you ask her? Just when? And she said, well, we call her up to the kiosk, and we, put a bracelet on her arm, and we ask him for the insurance cards. And I'm like, okay, you ask him for the insurance cards. He's sitting right there. What do you think she is going to say? And even if you asked me point blank, I don't know. Even if he wasn't there, I doubt I would tell you yes right off the bat. So I went to a new doctor the other day. You all are going to have to forgive me this story, but went to a new doctor the other day, and they handed me a clipboard. And on the clipboard, it's like, do you smoke? No. Do you exercise? No. Do you, how many surgeries have you had? How many, have you fallen lately? And then they asked me, am I sexually active? Am I sexually active? Well, I looked around that room and I thought, I don't know these people, and I don't know this receptionist, and I don't know this nurse. So you know what I said? Yes. Oh my gosh, I'm 74 and I'm like rabbits. I mean, Steve and I, yeah, it's all the time, everywhere. And I'm thinking, oh, you're so stupid. But so what happens is, like I say, the receptionist sees that. It's the most personal thing that you could ask me. What do you expect me to say? Am I safe in my own home? I'm not going to tell you about that. So basically what I bring you here today is how you you can help your clients live abuse-free. I want you to protect the promises that you make for LSC and for access to justice. So this is how I'm going to help you help them. So when I first started in this field, we operated on what's called a medical model. A medical model, and Emily, you're too young to know this, okay? But when we started out, women would come and they'd say, I can't eat, I can't sleep, and I cry all the time. And I'd say, okay, great, I've got 3 pills. Here's one, go get you a protective order. Here's another one, go get you an apartment. Here's another one, go get you a job. And she would come back and see me in a week. She'd come back and she'd say, well, I have a job, I have an apartment, and I have a protective order. But I can't eat, I can't sleep, and I cry all the time. So we were asking things like, well, did he hit you? Did he punch you? Did he burn you? Did he scald you? Did he shave your head? Did he stab you? On and on. But you know what we weren't asking is, how does that make you feel? How does that make you feel? And this is this trauma approach. Yes, you need to ask all those things to get, your ducks in a row on her case. But we should have been asking not what has he done, but how does that make you feel? You know what she's going to say? She says, I'm scared and I'm humiliated and I'm embarrassed and I'm betrayed. And you know what? I'm so stupid that I don't know how I let this happen to me. And we begin at that point to walk beside her, not lead her into the justice system, but walk beside her. And that's what can make a difference. With a trauma-informed approach, you'll be able to understand why she does not present well in court, why she wants to vacillate between, I want a divorce, I don't want a divorce, I want a divorce, I can't get a divorce. And it's so easy, again, for us to judge and say, lady, just let me know when you want one. I've got another manila file folder on my desk, right? Okay, so all of that's going to start making sense if you'll understand a trauma-informed approach. Now, let's say me, the real Jan Langbein, walks into your office and I want a divorce after 54 years of marriage because I'm so sick and tired about how loudly he eats his cereal. That's all hypothetical, right, girls? Right? Yeah. And I'm sure he's sick of me crying about how loudly he eats his cereal. But my procedure that's going to be really different from the lady I just mentioned to you. But over and above the legal knowledge, the knowledge of the legal procedures, where there is violence in that relationship, this is where your legal practice can become significant. Understanding the prevalence of domestic violence, the dynamics of domestic violence, the danger of homes where there's domestic violence, and also the panelists were talking about that, when he no longer can hit me or hurt me, he becomes, his choice of weapon becomes manipulation of the court system. So, according to Lundy Bancroft, and any other social workers in the room know exactly who I'm talking about. He's worked with men who battle for just years and years and years. And he says where there is contested custody, the majority of those cases have abuse in that home. Where there are firearms, the mere presence of firearms spark a divorce proceeding. A divorce proceeding can spark into something that can explode. And again, speaking of firearms, please follow that Rahimi case. We are desperate to get those clauses back in if convicted of a felony of domestic violence, if subject to a protective order. I don't know how they weren't thinking about that. I really don't. So we know, again, they talked about it earlier, that women are in more danger. And so I really want you to hear, because a lot of times this is where a lot of people just turn off old Jan, because I'm not against your Second Amendment rights. I'm really not. I mean, I'm okay with guns as long as you should have them and it's legal for you to have them. But I go on these rants and raves every time there's, another homicide with firearms, and, the press comes and says, well, what do you say when somebody says you're trying to destroy my First Amendment rights? I say, this is a really easy answer. Super easy. Don't beat your wife. Don't be a creep. Don't hurt somebody else, and you can have all the guns you want, right? I just don't understand how it goes from let's protect families to I'm trying to destroy somebody's Second Amendment rights. So how can you make a difference? How do you become trauma informed? And I know you're sitting there thinking, I am a lawyer, I am not a social worker. But if you want to protect the promises, you're going to have to wear that social worker's hat just a little bit. What is trauma informed? Trauma informed is being very careful with your choice of words, okay? Now, I forgot my timer. I didn't start it because I get going and I can't stop. But I'm just going to take a few more minutes, because a huge professional aha for me was when I discovered a study by a guy named Prochaska, and he did the trans-theoretical model of change. He says if you want to change anything in your life, there are 5 distinct stages: pre-contemplation, contemplation, preparation, action, and maintenance, okay? Pre-contemplation, contemplation, preparation, action, and maintenance. He was talking, his study was about the cessation of smoking. I'm going to use it in terms of exercising because I've never been a smoker. Actually, I've never been an exerciser, but I get the concept of exercising. I don't understand smoking. But anyway, so if you think in terms of most of the people who we see at Genesis or at Hawk, they are in pre-contemplation. They've grabbed their babies and run out the door. So if you get with them and start saying, let's get a divorce, let's get a protective order, here's your case, we're going to meet on this day, she sees your mouth moving, but she has no idea what you're saying, right? Contemplation is, gosh, I wonder what it would be like if my children didn't cry themselves to sleep at night. I wonder what it would be like if I were not scared in my own home. Preparation is maybe they look up Hawk on the website, or maybe they make a call to the National Domestic Violence Hotline just to kind of get some more information. Action doesn't necessarily mean that they went to Hawk. Action means they can name it and claim it. That's a real hard one to get to. They can name it and claim it. It was not my fault. It was not my fault. And stop asking me why I don't leave. Ask him why he did it in the first place, right? So that's action. And then maintenance is, I'm an exerciser for life, right? Which I don't know that I could ever get to. My husband's an exerciser for life. He'll come to a hotel and go to the gym. But here's the thing. If I am kind of going through these stages and I do go back, rather than you judge me, know that if you did your job and I do my job, they're not going to go all the way back to pre-contemplation. Anyway, I could do a whole lecture on Prochaska, but it was super important to me to realize, not only as an employer, but you have to be able to speak to someone in the stage in which they are, okay? Like I can't talk to somebody in pre-contemplation, hurry up and get out. But you know what I can do? Not only do you need to identify the stage that she's in, you also can help move her to the next one. Hey, what do you think this is doing to your kids? How safe do you feel? Do you know there's a National Domestic Violence Hotline 24 hours a day? That can help move her to the next stage. Again, I know you're thinking, I'm not a social worker. It will make a difference in your law firm. I promise you that. Another way to be trauma-informed, beside your choice of words, is your tone. You know, what is your body language? Are you hovering over her, or does she recognize you as someone who is there to help her, not hurt her? Body language, stressing confidentiality. You know, this goes no further, right? It's not just, hey, you're sexually active. It goes no further than right here. This is between you and me, and it's privileged. Of course, without judgment or bias. If you think, gosh, she should have left the last time, then you're not the right lawyer for her. You have to understand why she's still there. And this one's going to make you laugh. And I know you're going to say, have you ever seen the offices at Legal Aids? And by the way, yes, I have. I worked down there. But it'd be great if you could have a soft interview room for these women. We have actually put an occupational therapeutic sensory room on site at Genesis. Because of the trauma, because what they've gone through, we have a safe place for women to be able to tell their stories, and a safe place where children can re-regulate again. But anyway, this is my gift to you, is that if you want to know more about a trauma-informed approach, Genesis in our new non-residential center has a national training center on crimes against women, which stretches our national conference on crimes against women, the largest conference in America on crimes against women, and that starts in May. But we have this training center, and on February the 27th, if you're interested in this, they are going to be doing trauma-informed training for attorneys. And I absolutely can give you a link to that before I leave today, how you can sign up and register for that. But it's lawyers and legalese and all the things that you need to know about, but in a trauma-informed approach. So this summer, February 26th, all eyes are going to be on Paris, France, with the opening of the Olympic Games. And you'll see the torch come by all the way from Greece. And in early Greece, actually, the Olympic Games were not judged as they are today. Obviously, today it's the fastest time, it's the jump the farthest, it's run the longest. When they first started, back then, the definition of winners was everyone who crossed the finish line with their torches still lit. Anybody who crosses the finish line with their torches still lit. Each of us, again, has that opportunity, an obligation to help those who cannot help themselves. And it is with your help and those who hurt that they can find safety. And in doing so, your torch will shine brighter, it will stay lit, and you will show someone else the way. Thank you for being a hero in Legal Services Corporation. Thank you for wanting to make a difference in the lives of others. Thank you so much for having me today.
Thank you so much, Jan, for those powerful, really important remarks. I'm sure they will be with us for quite some time as we think about the work you're doing. We now turn to one of my favorite, most significant parts of these gatherings, the presentation of LSC's Pro Bono Service Awards. This afternoon, we recognize 3 distinguished lawyers, 2 important law firms, and a leading American company for their remarkable pro bono contributions to our 3 Texas LSC grantees, Legal Aid of Northwest Texas, Lone Star Legal Aid, and Texas Rio Grande Legal Aid. Now, as our LSC board travels to most every state before returning to one where we've held a formal meeting, and as our board only has 3 such meetings a year, although we'll be traveling a lot this year because of the 50th, but we will not likely return to the Houston area anytime very soon. And that makes these awards all the more special. They're particularly special, as I said, because they are the first awards we are giving in LSC's 50th anniversary year. And they reflect LSC's commitment to pro bono service, evidenced by our pro bono task force, most recently by LSC's Pro Bono Innovation Funds Grants Program, which has now awarded 139 grants totaling more than $40 million since its inception 10 years ago. These grants support projects that create solutions to persistent challenges in pro bono delivery systems or explore new ways to implement pro bono services so that we can reach more low-income Americans and help them with their legal needs. These funds are directed to grantee projects that we hope are replicable, scalable, and focus on critical unmet needs. Last year, LSC awarded Pro Bono Innovation Fund grants totaling over $5 million to 17 legal aid organizations in 14 states. Legal Aid of Northwest Texas received a grant of nearly $385,000 to help low-income Texans in their area deal with arrest and conviction records that need to be expunged or covered by non-disclosure orders. Well, this expungement project is recruiting and training pro bono attorneys to represent clients in court so they can obtain the requisite orders. Well, as we and you work hard to promote pro bono, we all know that pro bono really has to be supported by appropriately funded, structured legal aid programs that help to screen cases, provide the essential support that volunteer lawyers just have to have with training, materials, and expertise from staff attorneys who are so familiar with these kinds of matters. We all know how important it is to have pro bono lawyers working in conjunction with lawyers at LSC funded programs. But together, they've helped tens of thousands of people across the country, and they play an important role in LSC's mission to help ensure equal access to justice, to protect the promise. To expand these pro bono efforts by the private bar, though, we need to educate not only the public, but the greater legal community about the severity of the crisis in civil legal aid. As Texas legal icon and LSC Leaders Council member Harry Reasoner has argued, that lesson needs to begin in law school. And I quote him, "We need to educate the bar and our country on the consequences of a high percentage of our population having no access to justice. A high percentage of lawyers have no understanding of the great need for legal assistance in obtaining access to justice and the consequences of lack of access. It should be a mandatory bar exam subject," he said. The need for access to justice should be a mandatory subject in law school, with the opportunity to do pro bono work as a student. Students who do not learn of the need for access to justice and the consequences of lacking it will be citizens blind to one of the most important problems in our society. We need to do better. Well, this afternoon, our 6 honorees here are showing the way, and they are hardly blind to this problem, because their firms and their companies are devoting much of their time and efforts to expand access to justice for our most vulnerable citizens. And we are so grateful and the beneficiaries of their work. To give our first award, Father Pius, let's begin.
I'm getting your award, I'm getting it. Hello, I'm Father Pius Petrick, the Vice Chairman of the LSC Board of Directors. Our first recipient, before I sort of get into the recipients, I should say it's a delight for me to be here in Texas, the Lone Star State. That Lone Star emblazoned on the flag, the Texas flag, a constant reminder of Texan independence, a willingness for Texas to go it alone when it needs to go it alone for the good of her people. But that is, in some ways, can be misleading. Because I think the spirit of Texas is not just a sense of independence, but it is maybe even contradictory, in a contradictory way, married to a sense of the importance of community. And I think these two grantees, or these two recipients of this award, show that commitment that we see in Texas to the community. There is that sense of independence, but also that dedication to community. Jacqueline Moy, Jackie, who is now the Chief Counsel of Energy Transfer, unfortunately she's not with us, but some years ago was involved in disaster recovery in Victoria. She and a team of her lawyers from Porter Hedges worked for several years to bring disaster recovery relief, the rebuilding of homes to people who were affected by the disaster down in that area. And while Jackie's not here to accept this award, she wanted me to be sure to give a shout out to her firm at the time, Porter Hedges, who had the courage and the commitment to give a large number of lawyers the space and the time to be able to work on this pro bono project, the Victoria County Long-Term Recovery Project. So please, she's not here right now, join me in thanking Jackie as well as Porter Hedges for all of the work they did to bringing relief to the people in Victoria County. No group of people has a greater commitment to the community than mothers, I think. And I think our next awardee, Amy War, is a great example of that. It's easy, I think, sometimes to get caught up in popular causes. It's hard to go against the grain. When you are working with a group that has strange ideas, does things a little bit different, and the state is responding to severe abuse, as happened in the fundamentalist LDS Church many years ago, as many of you know, here in Texas. It might be easy to say, well, these accusations are true, let's go with them. But we, as lawyers, have to always understand that we balance our commitment to taking seriously allegations of abuse with a commitment to due process and the good of allowing that process to show the truth. And so Amy Ward worked to reunite mothers and their children who had been separated by the state of Texas because of these allegations of abuse. She realized the importance of mothers in the life of their children. So too also in the federal Texas detention centers, in which she worked to grant child care license to the federal detention center in Karnes City. It's a reminder of the importance of mothers and their children and that commitment to family. And so I would like to then call Amy Ward. Is Amy here? Amy, they were come forward. I've got a little certificate for you. Amy is she's a partner. I should mention the firm, the partner in the Austin office of Alexander Dubose, Jefferson, and Townsend. So we want to thank them for giving you the time to do this, and thank you for your commitment to Texas Rio Grande.
So good afternoon, everyone. As you've already heard, my name is John Malcolm. I'm privileged to serve on the Legal Services Corporation board. And it's my honor this afternoon to present Pro Bono Service Award to our next two awardees who were nominated by Lone Star Legal Aid. The first awardee is Kevin King, who's a partner in the Washington office at Covington and Burling, where he advises his clients on appellate litigation, constitutional law matters, administrative law matters. But in addition to that, he is a dedicated pro bono advocate who has pursued cases all the way up to the United States Supreme Court on behalf of his low-income clients. He was nominated for today's award by Lone Star Legal Aid for leading a team that sought relief and justice and trying to reverse a precedent that was used to deny virtually all excessive force claims brought by students against public school officials. His work provided invaluable service to a very vulnerable population. And while Kevin could not be here with us today, we are very, very pleased to honor his work. So in absentia, and I'm sure he can hear us somewhere, please join me in thanking Kevin for his service. Our next honoree is Michael McNally. Michael practiced law for over 50 years. He was focused on initially civil litigation and then later in bankruptcy. A resident of Tyler, Texas, and a longtime proponent of pro bono services. And he organized countywide initiatives in order to promote volunteerism in the profession. He helped found the Smith County Pro Bono Project and the Smith County Bar Foundation, leading both organizations from their inception. He was nominated for today's award by Lone Star Legal Aid for providing pro bono services to more than 600, you heard that right, over 600 clients over 34 years, as well as recruiting, training, and mentoring a new generation of pro bono attorneys to represent clients in bankruptcies. Michael also couldn't be with us here today, but we are glad to have his colleague, Ronald Stutz, who's the president of the Smith County Bar Foundation. Please come up here to accept the award on Michael's behalf. Please join me in thanking Michael for his service and on him.
Hi, I'm Abby Kuzma, and it's my pleasure to close out the awards presentation with our nominees from Legal Aid of Northwest Texas. We have two. First, we have Lon Lovelace, who will be joining us virtually, we hope. Is that happening? Oh, there he is. Good. Okay. Lon is a dedicated family law attorney in Dallas with the Webb Family Law Firm. He has established a strong commitment to providing pro bono legal assistance in Texas for more than 20 years, with a specific focus on serving rural communities where aid often is not as readily available. He was nominated by Legal Aid of Northwest Texas for his years of involvement with the Family Law Essentials Seminars, a program designed to recruit attorneys to take on pro bono cases. During these seminars, attorneys attend a CLE presentation without charge, and then in exchange, agree to take 2 pro bono cases from the local legal aid program. During his tenure as chair of the Pro Bono Committee and of the Family Law section of the State Bar of Texas, Lon has been instrumental in recruiting lawyers and judges to participate in these programs, as well expanding access to justice in smaller towns throughout the state. We are pleased to recognize him with this award today, and please join me in thanking and congratulating Lon. For our final award, rather than honoring a single individual, we're recognizing an organization. American Airlines, their pro bono attorneys, have a long history of helping survivors of human trafficking by obtaining expungements of their criminal records or non-disclosure orders. Survivors have a better access to safe housing, employment, and education opportunities and other benefits to help them rebuild their lives. I'm sure they're talking about vacating the record as well. American Airlines was nominated by Legal Aid of Northwest Texas for its participation and partnership in an expungement expo, assisting hundreds of low-income persons, including human trafficking survivors, to have their criminal records expunged or sealed. The airline has since expanded its reach by helping survivors with legal problems beyond expungements, partnering with New Friends of New Life, Jones Day, and Legal Aid of Northwest Texas to form a unique pro bono effort serving survivors of human trafficking. American Airlines has also recently donated 675,000 Advantage miles to Legal Aid of Northwest Texas, the first contribution of its kind in the organization's history. We're pleased to have Patrick Sanders, there you are, okay, Managing Director and Senior Attorney for Legal and Compliance for American Airlines, here with us today to accept the award on his company's behalf. Please join me in thanking and congratulating American Airlines. And I just wanted to say, it's this work is so important. I've been serving human trafficking victims since 2001, and these kinds of issues are so prevalent, and we're so grateful for Patrick.
Good afternoon. We had a busy day with wonderful awards. I'm Gloria Valencia Weber, and we're getting toward the close. And it's my pleasure to introduce Congresswoman Sheila Jackson Lee, who represents Texas' 18th Congressional District, centered here in Houston. We're truly meeting one of the senior people in the House of Representatives. She is in the 14th term as a member of the House of Representatives, where she currently serves as the Democratic Chief Deputy Whip. Representative Lee also sits on 3 key congressional committees. She is the senior member of the House Committee on the Judiciary, Homeland Security, and the Budget Committee. And she was appointed the first female ranking member of the Judiciary Subcommittee for Crime, Terrorism, and Homeland Security, which she now chairs. She is obviously serving in all the areas that our contemporary life has as everyday issues for our country. I have observed her in her hearings, and she is direct and committed to doing the best for our country. In addition to her many legislative accomplishments, she's very much part of what we have spent the earlier part of this event talking about. Representative Jackson Lee is the author of the historic Violence Against Women Reauthorization Act of 2022. So I really want you to give a great welcome to somebody who fits with what we've spent our day today talking about. Thank you.
Well, howdy. I hope that you have enjoyed some parts of being in Texas. And if you have not gotten a howdy, then I need to make sure as this meeting closes, you get a howdy. And how are y'all? I hope you're good. I'm delighted to be here and to be able to thank the members of the Legal Services Corporation Board, to thank and acknowledge all of the presenters, and to thank my dear friend and committed advocate for justice, and that is Justice Nathan L. Heck. I want you to give him a very big hand again. Do that again for me. And stand up. You're in the room, stand up. I'm looking all over. I might have missed him. I thought he was. This is sliding. Well, tell him he's getting a grade. And he should wave in for a moment. I can't start unless he waves himself in. After I've indicated to him that he is one of those who loves justice in the state of Texas. There you go. Judge Nathan Heck. It is extremely important. I want those of you to know who are from out of town how important it is to have a justice on the Texas Supreme Court affiliate and associate and have a great interest in justice being rendered unfairly, unbiased, and with an even hand, and being able to embrace the word justice. And that is Justice Nathan Heck. Give him another big hand, please. He was engaged and I was engaged as I was coming up. And so I wanted to make sure he knows that I really appreciate the hosting of this great organization. I certainly have been engaged with the Legal Services Corporation by way of the local organization as a practicing lawyer. I even served on the board for a period of time. It gives me certain credentials to say that I'm one of you and you're one of me. And to see you in this room and to be here today for the 50th commemoration of the Legal Services Corporation, I am humbled and honored that you are still on the battlefield. And what I would say to you is that the work is yet undone. And I know that you've had the privilege of listening to my colleague, the Honorable Lizzie Fletcher. I'm delighted that she was here. I'm going to speak extemporaneously, and we'll probably have dinner together. I got about 4 hours that I'm going to be speaking with you. So get ready and put the plates on the table. To my introducer, thank you so very much. It is a pleasure, Professor, to be with you and to know your great work, and to know your work as it relates not only to justice, but to our Native American community, our first Americans, which we should always be reminded of. And I can assure you, you have great leadership as we have opened the doors to members of Congress with such heritage, including our outstanding Secretary of the Interior, Deb Haaland, my dear friend. Please let her know. She was your student? Yes, ma'am. Well, then you call her up and say what I said about her, that she ran. We are working together on trying to preserve history, and that history happens to be the history of General Granger. I am going to get to the point. Anybody know who General Granger is or was? He was or was. He's not, he is now. Anybody? We have not done our work. Not done our work. General Granger was the general assigned by Abraham Lincoln to come to the shores of Galveston to finally make an announcement that the slaves were free 2 years after 1865, which generated into a holiday here in Texas that is unique. It was unique, called Juneteenth. And I was privileged to be and am the only sitting member of Congress that has created a national holiday. There are only 11, and so many of you should be aware, because the president signed it just about 2 years ago. Juneteenth is now a federal holiday, which acknowledges the freedom of slaves. Freedom. Truly a major component of why you're sitting here today. So let me thank the Pro Bono Service awardees, or acknowledge them and congratulate them, and also acknowledge the commendable work with the Legal Aid of Northwest Texas, which I was introduced to their leader as I came in, also to the Lone Star Legal Aid and the Texas Rio Grande Legal Aid as well. Serving 28 years on the House Judiciary Committee, I will just give you an overview because I see and realize that good works have been said by many of my friends including those who were on the domestic violence panel. I don't know if Emily Dawn Whitehouse is still in the room, but I served on the board with her. I served on your board years ago to the Houston Area Women's Center, and we are constantly on the front lines. The call that I made to you just about a couple of weeks ago, I've not forgotten. It is still something that we need to deal with, but we got caught up in trying to keep the government open, and so it kind of delayed me a little bit. But I was thinking about it, as they say, when you think about things in the dark of night, when you're supposed to be asleep, then you know it was a to-do list, and I said, oh my goodness, I haven't done it. And that is to deal with the issue of domestic violence and how women are received when they go to say that they are feeling that they're in jeopardy. And what has happened is you're told to take a pill and go home. We had that tragically happen here in Houston. And of course, she lost her life in front of her children. And I can't get over it. And so we are continuously realizing that domestic violence remains an epidemic amongst us. So let me try to do an overview of my tenure on judiciary and finish and shorter than those 4 hours that I said that I was going to do. I've enjoyed and was gratified that the leadership, when I came some years ago, gave me no other option because Barbara Jordan, my mentor, who endorsed me and was still alive when I ran for this position, and even my predecessor was members of the House Judiciary Committee. And Carol, I think, who I have the right name, who was a staffer with John Conyers. I got it right? Got it right. Was a staffer with John Conyers. And he was a tutor of tutees. But we started, we did things practically in the Judiciary Committee at that time. We were hands-on. And so my first recall was Abdou Diablo. And that was an unfortunate individual in New York that suffered at the hands of officers who mistook him for a violent criminal. And unfortunately, he lost his life, which was the beginning, I guess, of our concern for good policing and to have the kind of policing that would not generate into some of the situations that you see today. So what is it that gives life and purpose to all that you do? It is that you are the warriors, you are the armor bearers for those who cannot walk into a law office or even find the legal services office of their particular community. No comment on any one of you. It's just that the vulnerability of these individuals are such that they have so many challenges that sometimes it is even difficult to find the helping hand that is being extended to them. And that is yours. And so it means that we have to be extraordinary in our work of finding them, of working with the faith community, of finding those who would support an America that speaks particularly to the idea that justice should not be limited. Justice should spread out and be part of the very fabric of our lives. Justice should be something that maybe even your first grader would say, justice, mommy or daddy, is making sure that everyone is treated fairly. And as I've seen in the United States Congress, and particularly on the Judiciary Committee, we've had our share of circumstances, along with our fight to ensure that you are continued funding. When there were those who would say, well, what is the value of the Legal Services Corporation? Or we don't want them to be involved in this kind of work. They should be limited. And I remember that debate when we were talking about the issue of landlord-tenant and whether or not you should be involved in that, dealing with the whole question of evictions, which have become, through the pandemic, an epidemic of its own. All of us should remember, as I jump around, seeing those national news stories of carriages, shopping carts coming out of apartments being evicted during the pandemic, before we had devised a program where we could give rental assistance. And so we have to be the ones to articulate to the legislators, state and local, what we see people needing and how people can survive. And whether or not we should be involved in child support cases, yes, we should. And whether or not there are particular types of cases that generate criminal offenses that we should be allowed to be engaged in. When I say that, that is the bar, the civil rights pro bono bar. Because the idea of our friends on the other side of the aisle makes it very difficult for me to use that terminology sometimes, but that's what you see us doing in Washington. And you get people asking, what are you talking about? You just got through arguing with that person. I said, that's the genteel way of dealing with a person who you vigorously disagree with, our friend across the aisle. To convince the legislators that the work of pro bono should have no barriers and no limits. Because when you are desperate for someone else's voice to speak for you. We have something called the Justice of the Peace Courts, and that's where the first eviction cases go. And you should take a day to go to whatever your court is and just listen to those judges, some of whom want to do good. Tell about the painful stories that they are hearing, that there is no relief for these individuals. They have no resources. They're on the verge of being evicted, and they have no voice to speak for them. We have to be, as you have been, an advocacy sometime when it is unpleasant. For I know that you have been rebuffed, rejected, criticized for the work that you're doing or the work you want to do, and saying this is not what you should be doing. Too controversial, too many people against it. And that is clearly where you are needed most. If there is a bounty of people against it, you should be right in the middle of it, because your voice can be heard when theirs cannot. It saddens me that you are limited in your work dealing with immigration. Because maybe in your work of immigration, there could have been present day solutions that would help us devise a real, reasonable immigration reform, which I've worked on year after year after year. In doing so, we come up against the legislative rebuff that one, we don't want immigrants, we don't want migrants, but what we want is for everyone to go. Your voices as lawyers, finding the legal pathway can be a giant step forward for all of these persons who can only look to you for that gratification. For even as we met the family of Amadou Diallo and other cases dealing with police encounters of African-American male mostly, the cases continued until we were able to stand up a community of advocates who realized that we had to find a way to support those who protect us, and as well to find a pathway that those who are most vulnerable, in the instance of African-American men or African-American persons or minorities, could find a way of being treated that did not result in the loss of their life, did not result in the loss of Breonna Taylor, or the loss of many others, cafeteria worker, many others that we would find. And then we had to find a way that we wouldn't have a woman who confronted domestic violence, had a new life, 5 children, and unfortunately her former spouse came and killed her, the children, and the spouse, leaving only 1 child out of her 5 remaining. That's how violent life can get for people who live in the vulnerable lanes of life. And then, of course, not having food, because you cannot access the pro bono system, is a mighty challenge to have. And so my words are that we are guided as lawyers by the Constitution, which believes in equal justice under the law, reflected in the fact that our founding fathers, and I would imagine mothers if they had been mentioned, began that understanding at the beginning of the preamble to the Constitution. Many of you know that the words were, we have come to create a more perfect nation, a more perfect order. I keep that close in the Judiciary Committee. Why am I sitting there? Why am I engaged in debate? Why do I take up a slight umbrage and cause of great disagreement when my colleagues on the other side of the aisle want to undermine justice and equality? Because I believe it's a birthright, or at least as you're present in this nation, we owe you a sense of, or a framework of due process. The promise of justice for all is an empty one without access to legal assistance. And your work here is essential to make that a legal reality for low-income individuals facing serious legal problems. The laws of Congress are meaningless if they're not applied equally. And what you do with access to legal aid is critical to ensure that everyone receives the equal protections of our nation's law. Again, I take note of Legal Services Corporation, Legal Aid of Northwest Texas, Lone Star Legal Aid, Texas Rio Grande, and the others across the nation. Long hours, hard battles are what you face, and great disagreement. This will lead me to journeys that take a very long time. Reauthorizing the Violence Against Women Act that was ultimately signed by the President of the United States was not an easy journey. It did not happen right after the losing of the legislation, which was 2013. We were returned back year after year after year because we were not Democrats in the majority. We could not get it passed, just as we could not get the gun show loophole, the boyfriend loophole that we wanted to include in our domestic violence, our Violence Against Women Act. We couldn't get those passed because they offended too many people. And so Legal Services Corporation, take the words of Maya Angelou. They show you who they are, that is who they are. Let them know who you are. That even with the boundaries of law and the challenges of funding, find a legal and pointed way of indicating that there are persons who are unattended, untaken care of, my new word, if you are not in place. And the reason is because there are so many that go lost and left behind if legal services is not there to be with them, or even legal services not there to come to members of the United States Congress or the Judiciary Committee and say, I need this amendment, this is not going to work, you need to add this. We're losing cases or we can't take cases because we're being blocked by legislation that put a barrier into us serving the vulnerable and desperate people. We need champions of Violence Against Women Act, but we need champions of those who want to protect our children. We need champions of those who want to be able to have real gun laws with the real understanding of being able to have gun storage, to close the boyfriend loophole, to be able to ensure that guns are not proliferating because we don't have a regulatory scheme that says that everyone should, in essence, come under those laws, come under the laws to ensure freedom and justice belongs to everyone. Remember what I said. The bill was reauthorized in 2000, 2005, and 2013. But we had to wait until 2022, fighting one year after another because we could not convince Republicans to go ahead and do something that would save lives. Think of that as you work as a lawyer, that not only is your work in that courthouse, but how many lives will you save because you are working with the Legal Services Corporation framework and agenda that is passed by the United States Congress. That in fact, you will work with human trafficking because that was a provision I pushed to get in so that you also have the ability to deal with the issues of human trafficking, anti-human trafficking. And read your authorization to know that you can address that question along with sex trafficking, creating a demonstration program on trauma-informed training for law enforcement, which is something we want to take up and promote. And so when we think of laws, your work, let us think of them being intertwined. But in the mix of being intertwined, let me think of your passion, your willingness to go the extra step, to be able to fight just a little bit more, because we're leaving so many people behind. Those who are vulnerable to their own economic condition, they can't get private counsel. You are it for them, and they are yours. And as I leave you with the understanding of this great work, I want to make sure that you're aware that we did great things in the Violence Against Women Act. We expanded protections for vulnerable populations, such as youth, survivors without shelter, Native American women, and LGBTQ+. That had never been before. We're still being challenged, if you will, by dealing with the issue of shelter, which we had gotten in the legislation, the idea that you did not have to leave shelter if the rental, lease, or mortgage was in the hand of the perpetrator. We're still fighting that. We passed it, and unfortunately, we saw some of that removed in the work in the Senate. But I'm not giving up. Each year, we look to make the Violence Against Women Act more relevant to the people who are desperately in need for that kind of protection. We have to realize that domestic violence, which is what I think I was assigned to do, on a typical day, your materials show over 19,000 calls in our domestic violence hotlines nationwide, and abuser's access to a firearm increases the risk of intimate partner femicide by 400%. And in 2018, partner violence accounted for 20% of all violent crime. Remember, the children see this. And in many instances, the children are left with no parents, no guardians, no one to care for them. For me, this is an ongoing and unending challenge. It is an emotional one. It's one that I believe we all should take up as our cause, and believe that there should be no loopholes in saving lives, no loopholes in ensuring that the Violence Against Women Act is complete and whole, and nothing that undermines what Barbara Jordan said in the Judiciary Committee when she argued for we the people. It is not our individual selves, but you as lawyers, and I as someone who serves in the United States Congress on a committee that holds the Constitution in its hands and nurtures it, I should realize that my task is we the people. You've had a good day of knowledge and information. I've simply wanted to reinforce the crucialness of what I believe our oath that we take, both as lawyers and that I take as a member of the United States Congress. I will always continue to look for justice, and I will dig deep to find freedom. Maybe I will find, as I turn the corner, a better pathway for human rights. And yes, I will be honored to find justice, matching freedom, and human rights, and peace, and equality, and recognizing people that are typically not recognized. I believe we must remain committed to advancing and expanding access to life-saving supports and services to those in need. I've got to keep looking for the roof over that family's head. I've got to keep looking for a room for that child to do their homework and sleep in a comfortable bed. I've got to keep looking for that family to be warm together out of the rain, and maybe a miracle in Houston out of the snow. I've got to keep looking to ensure that the laws we pass are clearly laws that give us the hope of a better and brighter day. Regardless of who I serve with in the United States Congress, and I work with them all, I must have the hope that springs eternal. And I take an oath of that when I was sworn in to the bar, that I've always cherished. And then I took the oath when I was sworn into the United States Congress to defend this nation and its laws. Now I have the duty of passing laws that are worthy of my defense and worthy of your defense, worthy of our courts and our lawyers, bringing justice every single day. I'm grateful to the Legal Services Corporation. I'm grateful for you taking the moment to be able to listen and to be reminded of the champions of freedom and justice, such as Dr. Martin Luther King's dream, and as well Barbara Jordan's recollection of we the people. That is whose pathway we should be following. And I know for this, in spite of the good days and the bad days, we will wake up with a smile on our face, because we'll be in the justice business and the freedom fighting business. God bless all of you. Continue your great work. And thank you all for being here in Houston, Texas, in the 18th Congressional District. Thank you so very much.
Wow. Thank you, Congresswoman Lee, for those powerful and inspiring words. And congratulations again to all the awardees, and thank you for your ongoing service in protecting our country's promise of access to justice for all. My name is Frank Nooner. I'm from Lafayette, Louisiana, and I'm a member of LSC's Board of Directors. And this afternoon, it's my pleasure to welcome the Honorable Brett Busby to share some remarks. Justice Busby was appointed to the Supreme Court of Texas by Governor Greg Abbott in 2019. He was elected to a full term in 2020. Before joining the Supreme Court, he served on the state's 14th Court of Appeals for 6 years. He is the Supreme Court of Texas's liaison to the Texas Access to Justice Commission. And preparing these remarks, I reached out to retired Justice Eva Guzman, who previously served in that capacity from the Supreme Court. And she described Justice Busby's work. Says his work on the commission has been characterized by a selfless dedication to the underserved. And he has never failed to inspire others to do the same. And I know as proud as he is of his work on the commission, he's even more proud of his children. And Justice Guzman shared with me that his daughter Erin is an aspiring fashion designer in high school, and he frequently posts about her designs, and his son Will is aspiring to earn his Eagle Scout accomplishment. Please join me in welcoming Justice Busby.
Well, thank you so much, Frank, for that kind introduction, and thank you to my friend and former colleague, Justice Guzman, for her kind words. Good afternoon. It's my pleasure also to extend a warm welcome to the Legal Services Corporation Board to Texas, and wish you a happy 50th anniversary, and thank you for holding a forum on increasing access to justice here in Houston. I also want to congratulate the honorees and thank you for all that you do. And this is an important topic on increasing access to justice because, as we've heard, 92% of low-income Americans are not being served and cannot get help with their civil legal problems. So as an introduction to the panel today, I'd like to pose 3 questions about that problem. Why does it exist? Who can do something about it? And what should be done? So first, the why. Well, the reason the problem exists in significant part is because lawyers in the United States have a monopoly on the provision of legal services. It's not a market-created monopoly, it's a government-created monopoly. It hasn't always been that way in our history, and there are certainly reasons for it, ensuring quality and protecting the public from unscrupulous actors, among others. And we as lawyers have been very successful at establishing, expanding, and protecting that monopoly. For example, we require 3 years of increasingly expensive professional school plus a licensing exam. We offer no multi-level licensure as the medical profession does, and we permit no private investment from outside the profession that could help provide needed services as many other professions allow. And make no mistake, we have done so at the expense of those who need legal services but cannot afford to pay monopoly rates, as the data I just mentioned irrefutably shows. So who's responsible to make change? The regulators of the legal profession who set up this monopoly in the first place, legislatures and courts. It's the constituents who elected us who are not being well served by the system we set up. They are not the constituents of the legal trade associations, the bar associations. Those groups represent the supply side, the lawyers. They have helped shape the system to maximize their members' profits, and they have no incentive to change the system on the scale needed to address this problem if it would doing so would affect those profits. Thankfully, there are altruists in these associations, and many of them are in this room today, and I'm very grateful for all that they do because they've set up programs that do help many Americans who cannot afford civil legal services. But these groups are in a difficult position because they also represent rational economic actors who, unsurprisingly, don't want to give up their monopoly rents. So it's the regulator's responsibility to have an honest and frank conversation with suppliers of legal services and say, if you want this artificial government-created monopoly to continue and the extra profits that come with it, we must work together to ensure that it provides better services for the demand side, for the clients. So what can be done to bridge this justice chasm? Government funding is essential, as the LSC knows better than anyone. You're charged by our federal legislature with helping to ensure that the legal monopoly doesn't prevent we the people from effectively exercising our constitutional right to seek redress of grievances. Also essential are pro bono work, private donations, and the programs set up by the altruists in our bar associations. But sadly, even taken together, as you've already heard today, all these efforts are just a few drops in the bucket. Over 90% of the need is still unmet. This state of affairs is as unconscionable as it is unsustainable. Many trial judges throughout America, faced with a deluge of self-represented litigants, have been forced to seek help ad hoc from outside the legal system to cope. Systemic change is the only way to address this vast problem effectively, while also protecting the public. The time for talk about what others can do to help is long past. It's time for all of us in this profession to put our money where our mouths are. So our court asked our Access to Justice Commission to start by looking at 2 areas of change, which some other states are already trying. First, licensing paraprofessionals and community justice workers to handle simple legal problems for low-income Texans. And second, establishing a pilot program for non-lawyer investment in entities providing legal services to low-income Texans. You'll hear more about those from the dedicated leaders in our study in just a moment, and their recommendations are currently being considered by our court. I was personally involved in this study, and I was quite surprised at what I heard from some members of our bar who opposed systemic change. One frequent refrain was that we should significantly expand resources and funding for existing nonprofit legal aid organizations. No doubt about that. But for those of us who've been trying to do that for years or even decades, we know that you can't squeeze enough blood from that turnip to solve a problem of this scale. Another comment was that permitting non-lawyer investment so that lawyers can serve more low-income people who currently have no representation would put, quote, profits over people, unquote. Hearing that sort of Orwellian doublespeak from a monopolist would almost be funny if it weren't so deeply unfortunate. But I am not deterred. Rather, I'm optimistic that with the help of people of goodwill all across this country, regulators can do better. My request of the LSC today is to partner with the regulators, with the courts and the legislatures, to identify and promote promising ideas for systemic change, and also to partner with your grantees to take advantage of these programs as they're made available to better help we the people claim our inalienable rights and seek redress for our civil justice grievances. Thank you.
So we're going to follow up on Justice Busby's description of what has happened here in Texas. They saw a problem. They realized that at least part of the solution lay with rules that are promulgated by the court, and they meant to do something about it. So they asked the Access to Justice Commission to look into the potential solutions, and I'm joined today by two members of the commission who helped lead that effort. Michael Massengale is a former justice on the Court of Appeals for the First District of Texas in Houston, and since 2020, he's worked as an arbitrator and mediator at JAMS, the dispute resolution firm. And Kenan Wooten, to my immediate left, is a partner at Scott Douglas and McConaughey. She joined the firm in 2011 after working as the rules attorney for the Supreme Court of Texas, and also having worked at Baker Botts and as a law clerk to former Chief Justice Wallace Jefferson of the Supreme Court. So Kenan and Michael, let's jump right into it. Justice Busby sort of teed up how it is you came into being as the subcommittee's tasked with examining the existing court rules for opportunities to improve the services directly to low-income people. Michael, do you want to start off and talk about the committees that were set up and how you went about your work?
Sure. Well, thank you, Ron, and we want to thank the Legal Services Corporation for inviting us to speak this afternoon. We're certainly grateful to everybody in this room for all that you do to improve access to justice for those who need recourse in the courts but are unable to pay for lawyers under traditional service models. I think we're all aware of the justice gap, or as Justice Busby was referring to it, justice chasm, which I think is appropriate. Some of the statistics that we uncovered and we're using in our work for the last year, 90% of civil legal needs of low-income Texans are currently not being addressed by our system of legal aid and pro bono. We've got one legal aid lawyer for every 7,000 Texans who qualify. And so based on those shameful statistics, there really shouldn't be any genuine debate about the need to do something more than what we are already doing to address it. Fortunately, our state Supreme Court has been a true vanguard in this area. In 2015, our Supreme Court created a Justice Gap Commission, which issued a final report in 2016 with a series of recommendations to, among other things, increase data collection in this area, ensure adequate funding for self-help resources, and as became relevant to our work, to promote innovative technological solutions, including an examination of whether there are legal ethics rules that need to be revised to eliminate obstacles to innovation. So now, more recently, coming to the present, October 2022, the Supreme Court sent a letter to the Texas Access to Justice Commission requesting that we, and Ken and I are two of the commissioners, ask that the commission study existing rules and propose modifications in the two areas that were mentioned by Justice Busby, allowing qualified non-attorney paraprofessionals to provide limited legal services directly to low-income Texans, and also to allow non-attorneys to have economic interests in entities that provide legal services to low-income Texans while preserving professional independence. This is not a radical suggestion. As Justice Busby mentioned, other states are studying the same types of reforms, and some have implemented them. But the court's request to us was unique in some respects, particularly in that we were asked to really focus on applying these reforms specifically to aid low-income Texans. As chairs of the working group, we divided the study into three subcommittees, one focusing on the scope of practice of what these licensed paraprofessionals could do without the direct supervision of lawyers. Secondly, how to license them and oversee their work, a sort of nuts and bolts subcommittee. And then finally, a subcommittee on non-attorney ownership.
So Kenan, how did you go about your work? What was your method of gathering information and getting the views of others and analyzing the information you were able to gather?
Well, so as has been mentioned a few times already, Texas wasn't the first one to consider this. And so one of the things we did as an initial matter is look at rules from other jurisdictions and also orders from other jurisdictions to see what was happening there, understanding the unique parameters that had been set for our work. Similarly, we looked at the ISLES report that's referenced, I think, in footnote 11 of the working group report, because that had kind of combined, if you will, everything that was being done or being considered across the United States. So that enabled us to sort of drill down more readily than we could have if we had tried to do that work initially. We also engaged the National Center for State Courts. Harriet Myers was instrumental in getting that done for us, and it was invaluable. And I say that not lightly, but meaningfully, because what they did is brought to the table a wealth of information for us and also helped us to compile information, run the meetings, put together the report, et cetera. We invited subject matter experts to speak to the working group that was put together, some of those being people from other jurisdictions where these procedures and whatnot had been implemented. We also, with NCSC's assistance, had focus groups to get feedback from the community from various people with diverse perspectives. In addition, NCSC coordinated with our assistants in terms of who would receive a survey that went out to a lot of people and compiled those results for us to look at. Additionally, and I think critically for anybody who's considering this type of project in their jurisdiction, we engaged the State Bar of Texas early on by sending out a communication that let the members know what was going to be happening, and created, with the State Bar's assistance, a suggestions email address so that anyone could send feedback at any point along the way. And in fact, that email address remains live to this day. In terms of trying to ensure diverse perspectives, the effort was multifaceted, as you might imagine. So first and foremost, we have a commission. That's a great commission. We listened to them, talked to them about who to have on the working group, and we tried as hard as we could to ensure there was diversity of perspective, geography, et cetera, on the working group level. Then, as has been mentioned, we had subcommittees that were formed. Those subcommittees extended beyond the working group membership. So what we did is intentionally tried to get people with relevant expertise and with diverse perspectives to be on the subcommittees. One small example of many, on the subcommittee I was chairing on scope of practice, we were going to be looking at evictions issues. We had a representative from the Texas Apartment Association and also representatives from legal aid. That was important to have robust discussion and ensure all perspectives.
So Michael, as Justice Busby suggested, there are some embedded interest in the current state of regulations. And as we look around the country, similar proposals generated differing views. What did you hear most often, both about the potential promise of what you were considering as well as the perils?
Yes, well, everybody says they agree there's a justice gap and that it's a problem. But then what to do about it produces some fairly divergent perspectives. Now, candidly, the strong support for the kinds of regulatory reform that we've been talking about and that we studied, I found it comes primarily from those who've already been converted. These tend to be innovators, academics who understand that the status quo is not enough. And that's why we've got to find new ways to expand access to justice. But I didn't find a large group of lawyers for whom it was instinctive to think that we have to correct our existing rules in order to encourage reform. The learning curve is a little steep for those of us who've been taught since law school that strictly enforced boundaries on who is allowed to provide legal services are essential to preserve the integrity of the legal profession. But on the other hand, the opposition to these reforms is organized and highly motivated. We heard some of the themes to the opposition from Justice Busby. we heard repeatedly that allowing non-lawyers to provide legal services will turn law into a business that will not put client interests first, that lawyers working for firms with non-lawyer ownership will sacrifice their independent judgment and advice to clients in favor of maximizing profits. We heard that non-lawyers cannot be trusted to observe fundamental ethical principles, such as preserving client confidentiality and avoiding conflicts of interest. Even limited experimental programs to gather data and see if it's an idea worth pursuing are a foot in the door that will lead down a slippery slope to private equity controlling all law practice. And so the solution to the justice gap is simply fully funding legal aid, and that there's no evidence that reform proposals will actually increase access to justice. Of course, there are very good responses to all of these concerns, but those are the kinds of things that we commonly hear.
So, there's a number of people in this room who are not from Texas, and we're sharing and broadcasting this panel, and we'll preserve it for subsequent listeners, and many of whom will not be from Texas. And all of us are wondering what happened. What are your recommendations? And Kenan, why don't we start with you with regard to scope of practice and paraprofessional licensing?
Absolutely. And I think before I dive in, it's important to say that while there was, of course, some opposition, there was a lot of compromise and listening and productivity. This was an exercise that unexpectedly led to a lot of diverse views being expressed. But what I'm about to tell you, I think yields the progress that came about from the conversation. So first and foremost, we could go on and on and on about the substance of these recommendations, but you don't want us to do that. So there's a barcode in the materials here, and that'll take you to the working group report. The working group report has all of the recommendations that we're going to summarize at a very high level for you now. Specifically for the scope of practice subcommittee that I was fortunate to chair, the rule proposals are laid out in Appendix A to the report on pages 1 through 4. And then if you want to get additional information about the process, the discussion, and the recommendations, you can also look in the report at pages 28 through 35 and 40 through 46. But here's the real high-level overview. You'll see that we have recommended in the materials, this comes from the subcommittee, and with slight tweaks was approved by the working group and then approved unanimously, by the commission. We have a proposed new paraprofessional scope of practice rule, as well as proposed amendments to an existing Texas Rules of Civil Procedure that govern justice court proceedings. So as we've heard several times already, the focus of this work was on helping low-income Texans. One thing we had to do with that focus is define what low-income means in this context, because as a lot of you know in this room, that can mean a lot of different things in the space we operate in. So then what we did is identify the greatest area of need for increased access to justice for low-income Texans. That was family law, consumer debt, probate and estate law, and evictions. So what you'll see in the proposed new scope of practice rule are provisions for what licensed paraprofessionals can do with and without attorney supervision in the areas of family law, consumer debt, and the probate and estate law. You don't see eviction there, and there's a reason. In Texas, we already have a rule that allows authorized agents to assist both parties in eviction proceedings. So that's already on the books. We didn't need to put that in the new rule. However, you've also heard about this community justice worker model that's in Alaska. That's something that is addressed in the proposed amendments to the justice court rules. It's modeled after Alaska, but has a unique spin because we're Texas. And we need that. And so you'll see that that's addressed there. Also in our existing statewide rules for justice court proceedings, there is a provision that allows assistance. It's not defined, but it's allowed in any kind of justice court case. So what has been recommended in the proposed amendments is to relax the standards there a little bit and allow assistance with a little bit more discretion given to the justice of the peace along the way. I think it's also important to point out in the proposed new scope of practice rule that we did address what happens if a case develops in a way that it exceeds the scope of your license. That was something we knew might come up for these licensed paraprofessionals because it is limited scope representation. There's also provision allowing for requiring, a written engagement agreement in those spaces. And so I could say a lot more, but I'll stop there for time purposes and let you all just look to the recommendations. And of course, if anybody wants to discuss them in greater detail, you all have the contact information. I think I'm now covering Lisa's subcommittee, which is the Paraprofessional Licensing Subcommittee. Lisa Hobbs was the third co-chair of the working group and due to various reasons could not be here with us today.
Particularly rain.
Lots of rain. And so I'm going to go over at a high level the recommendations from her subcommittee. So those recommendations are again in Appendix A to the working group report, specifically on pages 5 through 8, and then on 10 through 20, you see a model character and fitness assessment. For more information about what her subcommittee did, the process, the meetings, the discussion, you can look at 35 through 38 and 47 through 50. I think before I tell you a little bit more about the recommendations from Lisa's subcommittee, it's important to point out that they had as a goal to create regulations commensurate with relatively low potential for harm given the limited scope of practice authorized for these licensed paraprofessionals. We had seen in other jurisdictions that if you overregulate, sometimes that can impede progress. And we didn't want to overregulate, but also didn't want to expose anyone to any unnecessary harm. And so there was a constant effort to balance those interests along the way. If you look at the recommendations in Appendix A for licensing, you'll see a section on qualifications, and that's a combination of education and experience. You'll also see that there's a definition of paralegal in there because in Texas and perhaps in many other states, a paralegal can be many, many different things and come with many, many different degrees of knowledge, experience, et cetera. There is a section in the proposal as well for examination. The proposal is to have a 1-hour ethics examination, also to have a 1-hour competency examination. There are some circumstances under which somebody can get a waiver. For example, in Texas, we have board certified paralegals in certain areas of the law. They wouldn't need to take a test to show what they've already shown through other testing. There's a character and fitness section in there for assessing character and fitness of the applicants. Again, as I mentioned, there's also a model assessment that's included to simplify matters for people. There is a code of ethics in these proposals. It's modeled after a national code of ethics for paralegals, but then modified, of course, for the licensed paraprofessionals at issue in this proposal. Finally, we have annual licensing requirements set out. There are dues that will be required. It's expressly stated that they would be less than the dues for attorneys. There's continuing legal education requirement in there. There are reporting requirements, and I think this is really important because one of the struggles that we have in the access to justice space is sometimes assessing what exactly is the problem. And so here, if the court were to go forward with the proposal, it would yield reporting requirements that could hopefully give us a little bit more insight in terms of how this program is working in the future.
Michael, what did you see with respect to non-attorney ownership of legal entities?
Yes, so in response to the Supreme Court's request, our proposal was to have a limited modification of the existing rule that prohibits non-lawyers from having any ownership interest in a law firm so that a pilot program could be implemented to experiment with these firms and non-attorney ownership, providing legal services to low-income Texans. And people often ask, what is envisioned by that? Congresswoman Fletcher was talking about how important it was to secure a name change for a victim of domestic violence. There's a non-lawyer-owned firm right now providing very low-cost name changes in jurisdictions where that is authorized. There's another firm that's very effectively and at low or no cost helping people obtain criminal expunctions. And so these are the types of services, legal services, that low-income people need and can be delivered at much lower cost than traditional legal services would provide them. How would our pilot program implement that? We suggested using an existing regulatory body that our state Supreme Court already has legislative authority to assign things for Regulation 2. There would be an application process and procedure, as well as rule guidance, to ensure that any of these entities that wish to provide legal services would actually provide legal services that are actually needed by low-income Texans. Some of the important features of that process, which we developed through lots of conversation with lots of the people who are expressing concern about such a change, include requiring that the proposed legal services be described in detail, including how they will expand civil access to justice for low-income Texans. And these firms wouldn't be allowed to provide any other service than these services that are specifically authorized. The firms would be required to make detailed disclosures and perform undertakings to ensure that these services are actually provided to low-income Texans, that they are provided consistent with existing ethical rules, just as apply to attorneys, particularly the protection of attorney-client privilege, client confidentiality, and attorney independence, as well as protection for clients against exploitation or low-quality services that would cause more harm than good. Our proposal would require that there be a Texas licensed attorney employed by the entity who's designated and identifiable to the public as a person who's responsible for ensuring ethical compliance within the firm. Our proposal would require these firms to engage in robust data collection and reporting so that the effectiveness of the programs could be evaluated. And there's much more detail, all in the same report that Kenan referenced earlier. There would be an annual process of reapplication and recertification for these entities in order for them to provide the services. Interestingly, the court did not ask, and our working group did not study or recommend whether these policies should actually be adopted. Our focus was designing a rule modification and change to accomplish it if they were to choose to go in that direction. But due to the overwhelming public comment that we received, which was very heavily in opposition, not to any of the specifics of our proposal really, but to the concept of allowing non-lawyer ownership of firms in general, ultimately our commission voted not to approve the rule modifications that we proposed. But as we've already mentioned, the work has been done and has been provided to the court, so they have our work and our recommendations, despite the vote of the commission not to approve them.
And just to be clear, on the scope of practice and the paraprofessional licensing, what did the commission do?
The commission approved that unanimously.
Right.
I should say there were some abstaining votes, to be 100% clear and candid.
And so the next step in the process is what?
So the commission has submitted a letter to the Supreme Court forwarding on the result of the commission's votes, as we just communicated to you, and also sharing the full report of the working group that made its recommendations to the court, as well as links to all of our work that led up to that and all of the public comment, extensive public comment that was received. Ultimately, the Supreme Court will decide what, if anything, it wants to do with that and decide on its next steps. It's our understanding that the court may be considering that soon, but historically, with other types of rule modifications, the court has relied on getting recommendations from a variety of different sources and well-established groups to provide it this kind of advice, including Supreme Court Advisory Committee, that typically will further refine recommendations, including the kind of recommendations that we made in this report. So it's really in the hands of the Supreme Court at this point.
So again, for our listeners across the country who may be in jurisdictions thinking about these sorts of initiatives, what advice would you give them as to how to initiate these sorts of inquiries and think about them and investigate them?
I think one piece of advice would be to decide early on whether the focus of the work will be limited to individuals with low income or more broadly focused to address the justice gap, which of course encompasses many more people beyond those who have low income. And I think that's a decision point that needs to be made at the outset because it of course shapes the recommendations at every step. I think another important thing to do is to invite feedback at every step, be open, be transparent. We made a point with the commission's assistance to put information online so people could see recordings of meetings, agendas, et cetera. And I think that's really important because sometimes the fear we feel is of the unknown. And if people can access the information and figure out what's really being proposed as opposed to maybe what they heard or what they thought might come out of it, I think that can help with having informed discussions along the way. And I'm sure there are additional thoughts.
Yeah, Ken and I could probably talk for hours on this, but we won't, knowing how patient you've all been here. One thing I would say is to be realistic about the timing. Of course, the needs are urgent. And we did a lot in the space of just over a year. But every state is different. The needs in every state will be different. And so anything you can do to identify what's specific to the needs of the low-income community of your state, what the deficiencies are, getting that information as soon as possible is very helpful because it's going to mold the direction of the proposals. I'd also say that spending a lot of time on outreach and coalition building is very important. I mentioned the learning curve on some of these reform proposals. It's my perspective that we encountered a lot of, for me at least, unexpected resistance from the legal aid community. People who had suspicion about the concept of anybody providing these types of services for a profit or a business motivation rather than through the familiar legal aid models or pro bono models. And anything we can do to encourage people to think of these as complementary programs that are expanding the number of people who can be served would be helpful to overcome those kinds of suspicions and be more open-minded about new and innovative ways to serve more of the same kinds of client population with the same kinds of legal services that we're just not able to provide enough of and reach enough people with our current models.
So I'm going to give you both an opportunity to speak without a mandate from the Supreme Court to our legal aid lawyers, our private practitioners, our judges, and other leaders, both here in the room and around the country. What's your call to action to improve access to justice in Texas and America?
I think for the private practitioners, a call to action is to always have at least one pro bono matter on your docket. It's easy to do, it's important to do, and I found that many firms support it. Another thing I think is important in conversations with the legal community and others to make sure that we're having the right question running through our minds, because the problem is such that we can't really ask ourselves whether we should do something, but instead ask ourselves, what should we do? Because things have to be done. And I will say this just for myself, I think this happens for a lot of us. We have fear of change and, fear of how these innovations might impact our business and whatnot. And I think we have to be disciplined and as selfless as possible in trying to process that and put it behind us when we assess what's in the best interest of the people in need in our respective jurisdictions.
Yeah, I agree with all of that. And I want to draw on my experience as a judge. I was glad to hear Justice Busby mention self-represented litigants, which are a really big component of the litigants in our court system. I know that the ideal really is for everybody who needs a lawyer to have a lawyer, but the reality is that that's a long way off for us. And there are right now many people in the court system who represent themselves, often very capably, but we need to do everything we can to facilitate that, both for the litigants and for the courts. And so anything we can do to modify rules to make them easier, to enable people to communicate clearly to courts about the relief they're seeking and why they're seeking it, or why they shouldn't be subject to some kind of other legal proceeding against them. And so, of course, the people in this room know what I'm talking about. Legal libraries, court navigators, basic forms that are easy to use, easy to understand online resources. These, I think, should be a major component of our focus and in what we're investing in. And also for the courts themselves, because oftentimes if somebody has the time to spend reading something that's been submitted, they can figure out what it's about and help them. But a lot of the submissions from self-represented litigants really do require a lot of effort, and they're very time-consuming. And so supporting our courts with the resources to do that, I think, would go a long way. And then finally, just making sure that we are changing rules to eliminate kind of technical, non-substantive means of flushing people out of the system, rejecting their filings, or technical reasons for refusing relief, when if you just apply common sense and an open mind and an opportunity for a path to justice, you can figure out what people are trying to do and not be overly legalistic about it.
Please join me in thanking Justice Massengale and Kennan for their thought-provoking presentation. And now, as the end of our day, it's my privilege to invite Harriet Myers, who really designed this program today, and on top of the millions of hours of other things she was doing, devoted many, many hours to this. Somebody thought that I should introduce her. It's hard to believe that there's anybody in this room who does not know Harriet Myers, but for the one or two of you who don't, let me say that she's a member of Locke Lord's Litigation and Public Policy sections, a former managing partner of the firm. She was President George W. Bush's Deputy Chief of Staff and Counsel, and prior to joining the White House, she had a distinguished career in her commercial litigation practice, and throughout her career, she's been committed to public service, as she is up to this moment. She currently chairs the Access to Justice Commission and serves as co-chair of LSE's Leaders Council, and we are blessed to have her there and here. Thank you.
Thank you very much for that kind and overly gracious introduction. But I just really have to say this has been a wonderful day, and hearing the presenters and all of the comments has been great. I'm reminded not to get in Jan Langbine's way. And there are a few other things I'm reminded about I won't say. But thank you, Legal Services Corporation, for allowing Texas to be part of your celebration of its 50th anniversary. We have been greatly honored by your presence in our state, and we're grateful for that. And thank you specifically, John Levy, for your constant, most effective, and inspired leadership of the LSC Board of Directors. You are one of a kind, wonderful. Thank you. And we're grateful for Ron Flagg also for his stalwart leadership, but also for many years of dedication to the Legal Services Corporation. So thank you, Ron. And I really want to thank all of the LSC staff for helping LSC in its efforts to fulfill what should be all of our promise to our country's low-income population, and that is justice for all. I have a special shout out personally to Carol Bergman, because we call her all the time and she gives us advice, and she's always there and always responds. And I just want to say how important she has been to us, and Jessica Wechter, who planned all of this and really deserves all the credit that Ron gave me. She has been remarkable, and we thank her. We are also especially thankful for all of the program participants that you have been able to witness. They've been great. We appreciate the day-to-day work that they do, the day-to-day work that some of our volunteers do, even carrying very, very heavy loads. So the two participants on this immediate panel were spending hours and hours and hours of work interviewing people, reading materials, suggesting proposals. I mean, it was an immense amount of work. And Lisa Hobbs, who was not able to be here, she is remarkable. And we thank our Bar Association. We haven't mentioned this, we should. They funded our work, and the National Center for State Courts expense was theirs, and we appreciated that, as well as participants along the way in the process. So we thank the State Bar of Texas, and certainly have appreciated Cindy's being with us today and conducting that amazing project. And then there's Chief Justice Nathan Hecht and Justice Brett Busby. Their contributions to these issues that we've addressed in this program are immeasurable for years and years. And they are national leaders as well as leaders here, and particularly Chief Justice Hecht with the Conference of Chief Justices and all of the work that has been done in this area. It's been amazing to witness, and we thank you both. And we are grateful to and pay tribute to Maria Thomas Jones, Robert Doggett, and Paul Furr for leading our programs here in the state of Texas. LANWIT, or Legal Aid of North Texas, we should say, Rio Grande Legal Aid, of course, and Lone Star Legal Aid. They are amazing programs, and we thank them for all that they do. And thanks to our interim director of the Texas Access to Justice Commission, Judge Laura Livingston, who came on board to help us at a time when we needed someone to do exactly what she's done, but she's done even more. And I'm supposed to remind you, please recognize that you can get CLE credit, thanks to Judge Livingston, for being at this program. And all you have to do is use that little QRC code to receive that credit. Our outstanding speakers today emphasize, while much has been done, you've heard a lot of work that has been done and continues to be done. There is so much more to do, and we recognize that. We thank everyone here in the audience for this program for their specific roles and concerns and thoughts and hard work. And we are grateful to you and want to continue to work side by side with you to get more done that needs to be done. And in 2024, programs just like this will be taking place all over the nation as we celebrate the 50th anniversary of this wonderful institution called the Legal Services Program and Corporation. It is of again, immeasurable value to the quality of our country and the ability of us to live up to what have been our promises since our formation. So come on board and help and work with LSC. This is a fundraising effort in many respects, and I need to mention that. This is calling on law firms and corporations and institutions, foundations across the nation. Let's put our money where our mouth is the old expression, and this is a great opportunity to do that. So thank you for being here, for your contributions to the program and all you have done that really resulted in your being here. So travel safe, and we'll look forward to seeing you soon.